Good morning, everyone. We're going to have to do this without the in-room amplification this morning. We've been informed, Lee just checked, and the remote is broadcasting us so that people can hear us and it's being recorded. It's just that the in-room speakers and amplification system are not working. So I'd encourage everybody, first off, the two rules of this are, of course, are you slow down, so because your voices are not amplified, and secondly, everybody, it's not like church. You can move closer to the front if you have trouble hearing, and we'll all try to accommodate each other. We'll have to be a little patient. Good morning. It's 9:40 for the beginning on June the 6th. We're here at the Low-Level Radioactive Waste Disposal Contact Commission in room E1.012 of the Texas State Capitol. First thing, of course, is the roll, and I see Mr. Salzman is here, Judge Goldner is here, Ms. Morris is here, Mr. Shoddock is here, Peter, you're here, and Lee Ng is here. Audrey Farrell, our administrative assistant, is in the back of the room. She's running around trying to see what we can do. I'll also introduce Jim Krause, of course, whom you're used to seeing, is our attorney with the Assistant Attorney General.
I'm sorry, it's going to be you just called. They said still turn on the mic.
Okay.
Okay.
The mic is on. And Karen Watkins is an Assistant Attorney General as of early in May, June? May 13th. And I've known Karen for well over, well, I won't say how long, because she's still young. But we used to be in the same law firm together. And so she's now an Assistant Attorney General. And Karen, welcome. She's going to be helping Jim, and she's learning about this, so she's attending today. So we have a quorum of the commission. I will note for everybody, Mr. Doyle is missing. Also, as most of you probably are aware, Milton Lee was appointed to be on the Board of Regents of the University of North Texas. He was confirmed by the Senate, and Mr. Carlson tells me normally there's not a vacancy until somebody leaves and their successor is appointed and qualifies to replace them. But in this instance, because he qualified for another appointed job, there was a vacancy created. And so basically right now, until the governor names a replacement, whenever that might be, we are down to 7 commissioners, 5 from Texas, 2 from Vermont. They have an alternate. We don't. In addition, our vice chairman position is currently vacant. That is subject to being also designated by the governor. And so the governor needs to do that, and the governor didn't do it for a while after this group of commissioners got appointed, so it's not really necessary, but it means some things internally that we'll have to take care of, but we can do that. So well, that's the story with the commissioners. Are there any, let me say, other than the judge, are there any other elected officials or elected folks or elected representatives of those guys here that I need to acknowledge? Normally Betsy Madru would come, but I don't see her this morning.
I did stop by and see my Representative Lewis, and he said he may stop in.
Okay.
He had to meet with the governor's office this morning.
All right.
Stop in.
Very good. We'd be glad to see Judge Lewis. He was one of the, Judge Lewis and Senator Seliger were the 2 folks that ushered through the legislation that we'll be talking about in a little bit. Is anybody from the press here? I like to introduce members of the press. It's a long-standing tradition of mine going back to when I first started attending these kinds of meetings. Okay, that's through items 3. Next we have items 4 on the agenda, public comment. And we do public comment that anybody can come talk to us at the beginning, even about something that's not on their agenda, if it's germane to our discussions or our business. Does anybody want to talk to us about anything on the agenda in particular? Karen? Karen sort of has a tradition of her own of always addressing us, and so I always recognize her.
Good morning.
It's not working, so you're just going to have to speak up.
No problem. Good morning. And I'll be brief this morning. Instead of written comments this particular meeting, Sea Coalition is just offering verbal comments. I will be bringing those forward as Executive Director. And basically, I'd like to reiterate our comments in regard to the applications before you today. We remain concerned that water is present at the site and there's no evidence that things are being pumped adequately to get the site dry. There's a safety factor here that we would like for you to consider. And we also remain concerned that there's going to be an increase in the transport of radioactive waste and hotter radioactive waste, and yet there have not been routes established for that transportation. We also have concerns about adequate emergency preparation for workers who might be called on to respond to an accident, first responders. And those are some of the concerns we have. And it's outside your purview, but we also are noticing that it's very difficult these days to keep up with TCEQ's maneuvers because they're passing a lot of things through, minor amendments that are actually major amendments that need time and public input and the opportunity for a contested case hearing, and a lot is sliding through there. For example, one provision included that you could bury waste even if there was standing water present in another part of the site. That's of great concern, and I hope that you will look at that and comment on it when you're able.
Thank you, Ms. Haddon.
Thank you.
Does anybody else wish to make any general comments of a public nature to us? Ms. Badru? I just wanted to say hi. Okay. All right. If there's no further public comment, the next thing on the agenda is, and I'm glad Betsy's here because we're going to talk about reporting on legislation which passed the Texas legislative session as it may impact the Compact Commission. And I'll just start the primary bills. There were two bills, really. One directly affected us, which was Senate Bill 347, and the other one was an indirect bill, Senate Bill 791. There were some other things that impacted us too. As most of you are aware, Senate Bill 791 passed the Senate, went over to the House, went out of the House committee, was being talked about on the floor of the House, and was point of order was raised, which sent it back to the committee. And at that point, 347, which had a similar path, passed the Senate, and it had gone over to the House, gone through the committee, and was being discussed the next day. There was a decision made by those directly involved in 791 to 347 dealt with our finances. So the 791 language was taken from it, not the entire bill, but meat from it was taken and inserted in the 347 on the floor amendment on the House. That passed, and the Senate concurred in the amendments, and it therefore passed out of the legislature. And I don't know who should be talking about this. I guess I will. Basically, there are a couple of things directly affecting the Compact Commission. 347 was a bill that was designed to clarify how our funding took place. And this for the Commission, the bill basically allowed transfers from the main low-level radioactive waste fund to the fund for operations of the Compact Commission. And what it says is that there's an amount appropriated, and that amount is appropriated from, and I'm going to shorten this, from Fund 88 to Fund 5151, that funds our operations at the beginning of each fiscal year, and we can spend up to the amount of the appropriation, and then if there's something left over, it gets transferred back to Fund 88. That's the general outline of the way it works. The reason for that, and it made it easy for us, one of the problems we've been dealing with is the fiscal problems associated, and this is true since the judge and I were first named to this to be experimental guinea pigs as commissioners in November of 2008. We've never had a stable financial situation for lots of different reasons. We operated for a couple of years, several years, under contracts with TCEQ, and then for the last biennium, we've had an appropriation that was kind of interesting in the way the appropriation worked, and we needed stability in that. And Betsy, thank you, and Senator Seliger for helping solve that problem for us. We really appreciate it. And it means a lot of things because it sort of stabilizes the revenues that go into our funding, and we know from year to year now, pretty much every time the legislature meets, we'll know what we have to deal with because of the mechanism for the funding. So thank you very much. The other interesting thing about that was in 791 but was not originally in 347 had to do with increases in limits for disposal. As everybody should know by now, and I'm not going to talk much about these provisions because just to note them, because we take them into account when we talk in terms of our import agreements, although it's just something we do. The original legislation in 2011 called for carry limits of 220,000 the first year, and 120,000 succeeding operational years. And it talked in terms of operational years. 791 and the provisions from 791 that got transferred into 347 now have a concept of fiscal year rather than operational year. And the limits were changed, so now non-party compact waste is authorized to be disposed of at the facility, and this is in the part that deals with the facility operator's license, of not more than the greater of, and they have a total curie limit now in the legislation of 1.167 million curies of non-party compact waste. And this is an alternative, and it's a greater of either of these, an amount of non-party compact waste equal to 30% of the initial license capacity of the facility. And then it says an annual limit of not more than 275,000 curies of non-party compact waste in any fiscal year. So TCEQ has the responsibility of administering those provisions under the license, and what we do is take them into account and John and I had a partial conversation about this, but in determining limits. So the statute will go into effect, I'm presuming, I don't know whether it's been signed. Has it been signed? No. And so it hasn't been signed yet, assuming it's signed, and I don't know, or goes into law without signature. I don't know why we would think it would not. It would go into effect September the 1st. So basically, right now we're still under the operational year requirement for the second operational year, which is 120,000 curies. That will be increased September the 1st to the new legislative limits of 275,000 curies per year. And so we have, in a year ending August 31st of 2014, there is room for essentially, if my math is correct, and Karen, you can correct me because she's done it already, the 275 plus the 120, basically. So it's that we have those kind of curies that could be authorized during that period of time, depending upon when the shipments are made and all that sort of stuff. For us, the way it worked for the Compact Commission was we never had a curie limit on approving import agreements. We did them on an annual limit basis because that was what the license required, and we thought that was a good way for everybody to keep track, and everybody would be keeping track that way, so we were doing it that way. So here we are, and there are some other provisions. Go ahead.
Could you, maybe Betsy, I don't know, there is a change in the yearly from April now, September 1st.
Yes.
Could you explain that too?
Okay. Operational year ran from April 27th to April 26th because the site operation date opened. Okay. Now we've changed to a fiscal year. So in the new law, so assuming that it goes into law without signature or is signed, beginning September the 1st, we will be on a fiscal year curie limit basis. But there are also other totals, other limits that have to be imposed that we will eventually take a look at, and one of them is the 30% capacity of initial, 30% of initial license capacity, non-party compact waste equal to 30% of the initial license capacity of the facility. And we may end up talking about that at some point. But there's also a curie limit of 1.167 million curies of non-party compact waste, and that's now in the statute.
That's forever.
And that's without regard to operational year or fiscal year. And if I'm not mistaken, and smarter people than me have done this calculation, but it's a happy happenstance that it appears the 1.167 million curies is about 30% of the initial license to curie capacity for the site. If I did that right, Lee, am I right about that?
I don't know. I have not done the math.
John?
I've done the math. That's correct. The initial license amount was 3.89 million curies, and 30% of that number turns out to be 1.167 million curies.
How amazing.
That's good. Because I was going to send all them back upstairs if it wasn't.
Well, we're still in a call session. So anyway, the other thing that was of note, and I think, and maybe some of the operators, I will note that I don't think anybody from TCEQ is here today, and the reason for that is that Andrews, they're having the grand opening celebration at WCS for the federal facility today. It happens to coincide today with our meeting, so TCEQ has its people up there rather than here, so we won't be hearing from them today, which may shorten the meeting some if I don't talk too long. And there are a couple of other provisions. The waste has to be beginning September 1st, 2015. It says the license holder may accept non-party compact waste for disposal at the facility only if the waste has been volume reduced, if eligible, by at least a factor of 3 in a manner consistent with the subchapter as provided before by Commission, and these are TCEQ rules, and that the compact waste disposal facility license holder collects a surcharge, and that's the surcharge for non-party compact waste disposed of at the site. And then it said, for those of you who are interested in such esoterica, if the volume reduction of a low-level radioactive waste stream would result in a change of its waste classification to class higher than Class C, the payment of the fee in compliance with other requirements of D1, which are the compaction and the fee requirements, do not apply. And I'm just pointing that out to everybody because if anybody thinks that the legislation made TCEQ or our lives simpler, they're wrong. They've gotten a little more complicated, and I'm sure and glad that John is still with us because we'll need to look at this along the way just to satisfy ourselves. And I think that's pretty much what I wanted to talk about with respect to 347. There was a clarifying language bill, but I think it just clarified some of the provisions of 347. That's House Concurrent Resolution number 214.
It's now in this.
It is. It's now in that.
Okay.
It's now in the version of 347 you have in your book.
Okay.
And I guess my last question on this topic is, it was a big deal in the legislature about each bill, not just this one, but a lot of them, about rulemaking, and there's nothing in this bill that has anything for us to do any rulemaking.
Not for the compact commission. That's correct.
Yeah.
In
We
some
may
way,
have some rulemaking, but it's not going to be because of the law.
That's right.
in some ways, it will guide some of the content of your rules,
Right.
but it doesn't authorize rules for us necessarily.
The one thing I'll add is that the legislation requires the TCEQ to conduct another capacity study to
That's
be
right.
due in December 2016. So just to let everyone know, another capacity study will be due 4 years from the last one.
Okay.
You said due in 2016?
Yes.
So that would be December of 2016?
Are there any commissioners from the commission members about legislation in Texas?
I think this is going to be an ongoing question, and it doesn't really directly involve this except this legislation. But this business of counting decay within the facility, or kind of negatively counting decay within the facility, I'm wondering whether that is reflected in any rules or statutes, and I'm wondering, I believe I know the position of WCS on it, that they would count decay, but I'm not sure that I don't know how the others feel about it, and they've drawn a line with the Curies, and I wonder what the statutory authority for that is, for the rulemaking authority, whether there's any guidance.
Mr. Chairman, could I?
Yeah, go ahead, John.
I'll offer an opinion.
Okay.
The way Senate Bill 347 is worded, it specifically refers to the initial license capacity in terms of curies, which is a set amount that can't be decayed. So it establishes, in my mind, a limit of 1.167 million curies. And then the language immediately preceding that says, compact waste facility license holder may collect a fee and dispose of. Dispose, in my mind, the way that sentence is written, means you're counting the curies when you dispose of them. You're not counting them 6 months after you dispose of them. You're counting them when you dispose of them. So that would tell me, at least I believe the way the language is written currently, we're not taking decay into account. I don't think the language allows decay to be considered the way it's currently written.
It struck me that way too, and I just wonder whether there was authority for doing it otherwise. But it sounds as if that's it. That's the rule. Thank you.
Mr. Bradford.
John, in terms of the impact of the facility, is it the amount that comes in that matters, or the amount that's there, or for some purposes it's one and for some purposes it's the other?
Well, I would say there's two answers. The first answer is, in terms of the legislation, it appears to me that it's amount that arrives and gets put in the ground. In terms of the ultimate performance of the facility, TCEQ, the compact waste facility operator, and then TCEQ as well, will do a performance assessment, if you will, and that performance assessment, typically when they're done, will decay the curies to what they currently are at the time, and then they will continue to decay those curies to determine what the dose would be to a member of the public under various scenarios far out into the future. So the performance assessment always takes into account decay to help determine what the
intruder who starts digging in the site, what kind of dose that person might receive, 100 years from now or something like that. So I think for complying with Senate Bill 347, it's today's curies. For the performance assessment, it's going to be decay, many years into the future. Does that answer?
Yes, it does. And just one follow-on to that. For the purposes of the performance calculation, are all curies created equal? No, different half-lives.
Different.
Yeah.
That's why it's critical that they know how much of each isotope is disposed at the facility and the date at which it was disposed, because in essence, every curie is going to be tracked, and you'll decay that down. But carbon-14 has 5,700 year half-life. So when you're looking at a dose to a member of the public 200 years from now, whatever carbon-14 you put into the site, it's virtually all of it is still there. Cobalt-60, for example, has a 5-year half-life. So 100 years from now, there won't be any cobalt-60 left for the intruder to encounter. It's all gone by then. So it's very critical that you track the curies by isotope. And then each isotope moves differently through the soil and the water and the air, and that's pretty complicated analysis, but it's critical that you know the isotopes in the curies.
And I suppose they're also emit different kinds of radiation.
Absolutely. Beta, gamma, alpha, some neutron, so that all gets factored into that performance assessment.
A side note might be that when the petition comes before the commission, the quantities may appear to be greater because we can't say exactly when they're going to go in the ground. So we may be asked to approve a petition that has a greater number of curies than actually would be disposed of.
Sure. Because, again, we're not approving individual shipments. We're just approving allocations, and we, and maybe even the generator, doesn't know specifically the date that shipment or multiple shipments would be made.
Are the decay rates such that there would be significant decay within 1 year, say, that it makes a difference whether an amount is shipped at the beginning of the year or the end of the year?
Yes. Some isotopes have a relatively short half-life, less than 1 year. So,
but wouldn't those have tended to decay away at the point of origin?
They will, but if they take something out of the reactor and it has I'll just make up, let's say it has a 1 year half-life, and they store it in their pool for a year, then from the day...
You still got half of it.
You still got half of it. So, but it's significant. 50% reduction is significant.
Other questions?
That was a good question. I think it's been kind of out there in the forefront of the commission. And when he said that y'all's, you can talk in a minute, but I'm just saying that. I remember when he said what you said, the analysis, the
performance assessment.
Performance. I think that's where y'all were kind of coming from, right? If I remember right.
You can't do a performance assessment without taking decay into account. You have to do that.
And I'm thinking that's where they're coming from.
And I should just say, obviously, I don't represent the TCEQ, and I'm not offering an opinion one way or the other. But as far as I know, they have not determined whether they think there might be rulemaking authority for county decay in terms of what they might do. Just raise that issue.
Thank you.
I will note that, Dan, you want to talk to us?
If you don't mind, I'd appreciate that.
Please come forward. We're very glad to have you explain what your interpretation of the language is.
I really appreciate the opportunity to do so as well, because this is an important factor. Chairman Salzman did a wonderful job explaining, some of the nuances of all this aspect of it. I would note a couple things. Number one is, with respect to the performance assessment, our license requires us to update that on an annual basis. That's what TCEQ approved, and that's what we do. So on an annual basis, we actually will decay our inventory, provide to TCEQ under our license a final report for that year, which states that we have 200,000 curies of inventory. Very well, and it will actually be, when we do the performance assessment, we will have receipts in excess of that 200,000 because decay occurs. We'll take in 300,000 curies over that 2-year period, and we do the report at the end of the year. We'll say there's 200,000. So 100,000 of the curies will have decayed. And so our license is driven by the actual conditions which drive our health and safety considerations, which is the amount of curies that are in place at any one time. So in actuality, the most important number here is the inventory. It's not the receipts, because if 100,000 curies of cobalt have decayed, they don't exist anymore. Therefore, they are not a problem. They are not representing a hazard to anyone. So that's why TCEQ has put that in our license to reflect reality, not a bloated number. And if you want, I will take an action to give you the citations in our license which state that we take care of the decay. The TCEQ has directed us to consider decay when we look at the total activity or the inventory of our site, if that would be helpful.
Now,
so from a regulatory perspective, that's what we're driven to do.
okay, well, that's for the activities on your site.
Yes, sir.
It's not for the amount that you are authorized to accept, right?
But I would also point you back to the earlier conversation that you all had this morning, was the calculation that we were doing up here about the 30%. The basis for that number in the bill that we see is 30% of our license limits, which references decay. So I would offer that as an opinion, because since that is founded on the total activity, which is associated with the decay, and it's associated with that, so it has a similar basis. So therefore, I would tell you that it ought to be interpreted such that it does include decay, because just like it's referenced into does.
Could you please provide me that reference when you get a chance?
You betcha.
Thanks.
Any more questions for Mr. Sherman? I will note that the language in 347 does say it may dispose, the licensed facility holder may dispose of not more than the greater of 1.167 million curies of non-party compact waste, or an amount of non-party compact waste equal to 30% of the initial licensed capacity. I will also note that the words 30% of the initial licensed capacity are not further qualified. And there are two types of capacity. There are volumetric capacity and there are curie capacity at the site. And while I agree that the performance assessment, and this is, and I'm speculating here, and I probably should just be quiet, but I think that there is a reason to concentrate on the curie compact content of waste as it is disposed that relates to fiscal provisions as opposed to health and safety provisions. So the performance assessment is sort of independent in my mind, because you're looking at radiation health physics and license limits at the property line, basically, and to try to see what exposure is there, and you have to continue to update that calculation if I'm stating that correctly from my layman's perspective, as opposed to doing a calculation on fees that may depend in larger part upon what the curies were at the time they were shipped and disposed of at the site. Is that fairly accurate?
I actually I think that's a really good summation of it. And where you have, and again, I go back to the foundation there. So if you make the rationale that the carry limitations that are associated with fiscal concerns, such as a fiscal year basis, the 275, I would say, no, those are not decayed. So on an annual basis, that 275 is what's manifested in what we received. However, I would also again note, though, that the second part of that, the cap, the total cap, is not associated with that. It's more associated with the foundation of our total license limit, 30% thereof, and that is reflective of the conditions at any time within the operating life. And that's why we do the performance update. So decay should be considered for that second portion.
Do you think that decay is also going to be one of those things that has to be taken into account in terms of the updated capacity study that will be due in 2016?
Yes, sir.
Okay. Yeah. So as I said earlier, anybody thought our lives got more simple, they should be laughing because they are not. It's more complicated now, I think.
It got no simpler for TCEQ.
It's about laughing and crying.
Well, it didn't get any simpler for WCS or TCEQ or us or anybody. It's just, it is what it is, though. We all have to learn to live with it.
For what it's worth, I don't think it's a close question now, having heard all this. I mean, I think you've got to get a change in the law if that's what you want to do, because it just, you know, every day lawyers have to interpret closer questions than this, so for what it's worth, I'm not a Texas lawyer, but.
Yeah, and I think your statement about yes, this is not a closed question is accurate. But we'll work through it together like we have been. So.
Well, fortunately, this is primarily a WCS TCEQ question that we have to pay some attention to, but it's primarily considering the licensing functions of the state of Texas for the site as opposed to what we do, which is improve import and export agreements. I forgot to mention that the legislation also says there is a restriction now against acceptance of Class A.
Non-containerized Class A. Yes.
Non-containerized Class A waste.
That's right.
And that applies both in compact and out of compact, if I'm not mistaken.
No, I think that's just out of compact, non-compact.
Just non-party compact waste. Okay. So
I'm sorry to keep.
No, you're fine.
Keep this up, but on the 275, the switch from 120 to 275, how do you think it's clear how that works, and if so, how do you think it works in terms of dates and adjustments and so on?
Yeah, it's very clear to us that the 275 is that the first curie of the 275 begins on September 1st. And right now, as you said, we're operating under the current rules, and the current rules say that we are allowed to receive 120,000 curies between now and April 26th of 2014. So we...
Okay, wait a second. So the 120 goes all the way to April 26th of 2014, is that what?
That's the way the current law states. Yes, sir.
And then...
I think Bob's going to help.
At what point... Okay, I'm sorry.
The question that you're asking is, can they dispose of 120,000 curies under the current law for the current operational year prior to August 31st of 2013, and then start disposing of 275,000 curies in the first fiscal year when the law goes into effect?
I'm just wondering whether that's a question or whether that pretty clear on that.
I think that's a fact, that they can do that.
Okay, so you start counting the 275 as of September 1st.
Yes, sir.
And until then, if they can cram 120,000 in there, they can do that. If they can't, they can't. And then it doesn't, the 120, what do you think, Dan? Does 120 carry over into the, or is it just gone?
No,
I think it's just obliterated.
It's replaced.
Yeah.
I think it.
So you think it expires with the start of the new fiscal year?
Yes, sir.
That's WCS's position,
Yes, sir.
that the 120 operational year expires on August 31st.
I believe so. Yes, sir.
Okay.
Yeah, that would make sense because that provision of the statute got replaced.
So, yeah, I don't think we're of the mind that we can get 395. I don't think we're of that mind.
Okay.
That's why I asked that question about
Carry the minutes
the new date.
No carry over the next.
Audience to be available to that, because everybody has to be on the same page at these meetings. Or it makes Betsy's life a lot worse.
Well, we try to get there, but I'm not sure we always are successful. But
I've got 2 bills for her to work on, because I'm counting right now. For the next time.
any more questions for Mr. Trump?
Thank you for the time.
Thank you, Dan. Appreciate it. Are there any more questions about the legislation from the commissioners? Okay. That's just the report. We didn't have any action. We were just reporting on some of the implications. And then next is item 6, because I think that takes care of item 5. Discussion and potential action on matters relating to establishing the generator of low-level waste for purposes of the applicability of commission rules. And Mr. Salzman.
Thank you, Mr. Chairman. This was a question that's been raised several times over probably the last year, perhaps somewhat longer, and I believe I can't remember which meeting, several meetings ago, I was asked to chair a subcommittee, I guess, and to look at this question, and it's been phrased different ways. One is, when does the waste become a waste? I prefer to refer to it as who's the generator of waste. Myself and Ms. Morris and representatives from TCEQ and Department of State Health Services met, I believe it was in March, to talk about this and kind of put our ideas on paper and sort of formulate what our thoughts were. So in the initial write-up of that, I chose to sort of make it into a question, and that question was, who is considered the waste generator when radioactive materials are to be disposed of at the Texas Compact Waste Facility located in Andrews County, Texas? And I think that, to me, that's really the germane issues. Who's the generator? I think that after discussions amongst ourselves, there's a couple of questions or a couple of reasons why that question is important. The first one is because of the legislation that exists in Texas law that says that if you're disposing of waste at the compact waste facility and it's from out of compact, that is, it's from somewhere other than Texas or Vermont, there's a requirement for a 20% surcharge, at least 20% surcharge. I guess it can be more than that. So we need to, for any waste that comes into the facility, we need to understand whether it is compact waste or non-compact waste and subject to that 20% surcharge. Secondly, Texas law specifies that no waste of international origin may be disposed of at the compact waste facility. So I think irregardless of whether the waste is compact or non-compact, the law says it can't be waste of international origin. So we need, that's another reason for understanding who the generator of the waste was. And the third one is really, I think, back to the duty of the commission, which is we need to protect disposal capacity for the compact party states, Texas and Vermont. So for me, those are really the three reasons why we need to understand this question and why we need to have, as when we got together and talked about it as a group, why we need to have some guiding principles to help generators and people who have radioactive materials and eventually perhaps radioactive waste, help them understand sort of a decision process to go through to determine who the generator was. In discussions with dishes and TCEQ and some generators, primarily this question is related to the disposal of field sources. Though it can come up for other materials, and in the white paper that we put together we talk about other materials, but primarily...
That's tab 11, by the way.
Oh, yes, I'm sorry, in your handout. And are there copies of this document? In the back of the room there were copies of the documents that are available. But primarily it's for sealed sources. And we've had this discussion in commission meetings before where a sealed source can get manufactured in one state and get sold to somebody who lives in another state or maybe another country, and maybe that sealed source gets shipped back to the United States and gets used in the U.S. And sealed sources, obviously, just by their very nature, can move all around the U.S. and the world. So the question becomes, when that source is no longer needed or wanted by someone, eventually it will become waste and needs to get disposed of. And that's for protecting public health and safety, and for various reasons we don't want sealed sources that are no longer needed to be floating around because they could be put to uses that would not be beneficial and could cause problems with public health and safety and security and lots of issues like that. So we also recognize that and I'll read through here to get the dates, but the Barnwell, I believe it was in July of 2008, began accepting waste only from states that were within the Atlantic Interstate Compact. So at that date, if you weren't in the Atlantic Interstate Compact, you had no place to dispose of waste, and in particular, in this case, sealed sources. So various companies in Texas, Vermont, and all over the United States had sources that were either still in use or perhaps they were radioactive material at that point, or radioactive waste, but they had no home or place to dispose of those materials. So they had to hold them. And I think probably within Texas, and I'm assuming within other states, regulatory agencies didn't want to see sealed sources in unsecured situations. In other words, it's better, even if a company X doesn't have a way to dispose of those sealed sources, it's better that a company X who has proper security and storage and shielding and all those kinds of things has those sources rather than a company who says, this is a source and we're getting out of the business, we don't need it anymore, I don't really want to hold on to it. So many sources were transferred to companies who had licenses that could properly and safely and securely store those sources. However, they may not have had a place to dispose of it until the facility in Texas opened. And companies, whether they're in Texas
or Vermont or some other state now have the opportunity to dispose of those sources or other radioactive materials properly. However, in that interim between the date April 27th, 2012, when the facility opened, and try to get the dates right, July 2008, there was definitely a window in there when there was no option. And there were during that period, the forms that exist today in many cases did not exist back then. Forms, TCEQ has a form, and I can't remember the exact number, 2225 or something like that, which sort of addresses the paperwork that's necessary to dispose of materials, and the generator has to put information on there and sign the form, and that form didn't exist. So the white paper that we put together took into account that the situation that exists today and the paperwork that's necessary today wasn't available, didn't exist for a period of time. So there may be other kinds of paperwork that the Commission would be willing to accept to help determine who the generator was. And we've sort of already done that on a couple of our applications. We looked at various kinds of records. For example, maybe a shipping manifest that said sealed source was shipped perhaps from a company in California to a waste broker in California. So that paperwork, though it may not, it's not exactly the same as the TCEQ form, it is a way of establishing where that source came from and who it went to. So the company that shipped it was the generator, and the waste broker then just is receiving that waste. So the white paper that we put together tries to take situations like that into account, and also take into account that we still have to comply with the basic premise, which is if it's out of compact, you have to pay the 20% fee, and we can't take waste of international origin. So there's a document that was in the back. It's 4 pages long, and we tried to put in words our thought process for sealed sources primarily, but other materials as well. So I'll stop at that point and ask if there are any questions. Well, let me add one more thing. The thought process behind this was that we put a draft document together and we put it out for comment. Hopefully everyone understands this was our best attempt. Realize that there perhaps are mistakes or things that need to be changed or further clarified, but we had to start somewhere, and hopefully this is a reasonable beginning, and I think comments would be helpful before this process moves forward however it should. Now I'll entertain questions.
Other questions from any of the commissioners? I just wanted to say that and I'll ask you this question for myself, is we have a white paper that we're calling a draft on an analysis of this subject. Does the committee have some concept about what would be done with this draft or the principles elucidated in the draft?
Personally, I'd love for it to just stay a letter, if you would. I think that would make our life much simpler, and if it could be a letter or a statement, or, I mean, there are various kinds of documents that regulatory agencies have.
FAA calls them advisory circular.
Advisory circular, regulatory guide. I'm sure the audience could put in 3 or 4 other kinds of names that a document like this could have. However, it could also be a rule, and I'm afraid my limited legal capacity, which is 0, doesn't allow me to offer what's the right way that it needs to be done, other than I do think somehow it needs to be, we need to receive comments we need to factor those comments in. We need to perhaps have more drafts. And then at some point, it's my opinion that the commission and TCEQ and DISHES would use the document, whether it's a rule or a regulatory guide or whatever it is, as a sort of guiding document for making decisions with regard to waste.
Okay. Questions from the commission?
Judge?
I was just thinking, I live in an oil and gas economy county. The oil and gas in this state's a big deal, and I'm like my compadre here that we need to open this up to some type of bigger gamut to get everybody involved, because we have the issues of Halliburton's and international companies that base, maybe not base here, but you know, where's their office, where's all this other stuff. I think that's going to come up, and I'm like John, if we do it in a rule, it's going to come up real quick. Because somebody's not going to, they're going to have the door slammed in their face and not had any input.
I think that the TCEQ and the commission needs to be on the same page, whatever happens. But I see this more as a regulatory guidance right now, guidance for the commission.
Okay. Mr. Crossan.
Actually, if I could add one more thing.
Sure.
And that would be, with whatever form this document finally takes, the premise behind it is that all generators, source manufacturers, waste brokers, decontamination facilities, and there's probably others, would be treated the same, if you will, so that decisions that have to be made are made uniformly, and it's not this company got treated this way and this company got treated another way. It would hopefully allow a framework that everyone would be treated the same. Now, not everyone may agree, but at least you would have some uniformity as to how decisions are made and how individuals and companies are treated.
All right. I'm going to make a couple of observations, and then I'm going to ask Mr. Crossan for some help. And my two observations are that we're subject to acting pursuant to rules, and there is a long honored in Texas, and I'm sure this is true in Vermont also. There is a multifaceted, fuzzy area when something is a rule and something isn't. And so what Mr. Crossan and I have been in conversations about, first of all, how, if we adopted this, what would it mean in reality if it weren't a rule, or if it is? Secondly, how it would be applied, how it would work. The second observation I'm going to make is that in this text on Ms. Morris, what she said, we can only look at what our interpretations are. We can't do them for TCEQ or Department of State Health Services or anybody else. And so we're trying to create and it's more than a dialogue because there are more than two people involved, but it's a process of where everybody can share ideas and come to the same general conclusions and work out how we're all going to, first of all, see if there can be principles that are applied to making these decisions, and at the same time leave ourselves the ability to know that we cannot possibly anticipate every situation that's going to come up and what happens if it doesn't. And at that point, I'll ask Mr. Crossan, what is our requirement for rulemaking when it comes to this kind of thing?
As you've already pointed out, Mr. Chairman, it's a fairly complicated area, and the Third Court of Appeals here in Austin has made most of the law in this regard because they routinely hear appeals from state agencies, and this is what the rulemaking process that your commission is required to follow. And when is a rule is something that administrative law lawyers deal with daily. And it's something that happens at district courts here in Austin and in the Third Court of Appeals here in Austin with varying results. It all depends on the general effectiveness of the rule, the application that's made of it, whether it's applied to everybody equally and the effect that it has on the regulated community. And I would say that based on what I've read here, that I would advise that we add this to our rulemaking process as a matter of safety.
Okay. And just so everybody's clear, the next item on the agenda is we promised ourselves we'd take a look at import and our rules, basically, in 675, 21, 22, and 23 related to exportation and importation of waste. And so, although this item 6, has for the potential action on matters relating to establishment of the generator, my question is, how would this one work in connection with, I'm just going to introduce this, with what we already do in our rules for importation and exportation of waste, primarily importation. And is it appropriate for it to be these principles and concepts to be outlined in that discussion? Mr. Salter.
I think if that's the appropriate administrative method, I think these principles could be incorporated into the rule. I should remember the number, 675.23. Mm-hmm. I think these principles could be set forth in that document as the guidance that the Commission is would choose to use for making generator decisions about waste.
And who our agreements would be with, I suppose.
Correct.
Okay.
Obviously subject to, as any rulemaking process, comments, which we will desperately need.
All right. I don't know that any action is required on this item as a separate item because we have the next item. So I'm just going to move to the next item on the agenda, which is discussion of potential revisions to 31 TAC 675.21, 22, 23 related to exportation and importation of waste. And Mr. Krausen is more familiar with this because I don't keep these things in my mind the way I keep other things in mind. But we promised ourselves that a year after our rules went into effect and that we had to pass as a result of legislation in 2011, we'd open it up for review. Is that more or less it, Mr. Krausen?
It is, and that we promised ourselves that we would look at about this time at the volume issues because we've been operating on the basis of we'll learn a lot as time goes on, and I think probably all of us have learned a lot, and there are issues, not major, but there are issues with our form agreement that need to be corrected. There are issues with the form of the application that need to be corrected, things that we've learned over the period of time that we've operated. And if we have the kind of open process that we have all had in the past, we'll get lots of comments, I suspect, from the public, both from the community that seeks approval and from the community that tries to keep us straight. So,
All right. So everybody knows that it's my intent to basically designate a committee, as we did the last time when we were developing these rules, to have a series of meetings the way we did when we developed the rules originally, and encourage participation of interested stakeholders in the process. I will also say that at least one person here today, Mr. Selig, had asked me when he saw this item on the agenda if there was a draft rule, and I said no, there isn't one, because we are just entering into the process, and basically the way I envision the process is that, and this is just personal, is we take the existing rule and what we've learned in the last year and have meetings and where we can get together with those who are interested. It wouldn't be the full commission. It would be this committee, and we hopefully run it as we did before. Unfortunately, Mr. Milton Lee took on another job, and so I can't tap him anymore. But we would then develop to see if any rulemaking needs to be changed and what it would be, develop the rule and the rationale behind it, publish it in the register. So it would be an ongoing process that we, in effect, start today. And that's my intent, and I have committee members in mind, and I've actually discussed it with a few of them before Mr. Lee was chairman of the committee, and he's no longer with us, and so I have told myself that probably I need to be, because I'm here in Austin and Lee Ying is here in Austin, we probably, and our attorneys are here, we probably need to be the focus, so I'm going to put myself on the committee to develop the series and schedule them and get the word out. And Mr. Salzman previously served very well, and we thank him. He's going to have some logistical problems this summer, and so before talking to him, and I'll let him talk about that, but I asked Ms. Morris if she would be willing to help us from a technical perspective, and she has agreed to do that. So Ms. Morris will also be a member of the committee, and Dick or Peter, one of you gets to volunteer.
I figured they'd volunteer the other one.
Are they allowed to volunteer James?
Yeah. James might got outvoted.
Okay. And Dick will be the third official member. I have promised myself that if we need help from the outside, in the past we've gotten help, Ken Krieger, to assist us, but in this case we're going to have a working group, if you will, that will meet to talk about it. I have toyed with the idea of telling Milton Lee that just because he's now a regent at the University of North Texas, he's not exempt from being put on the committee. So I think he's got other plans. So initially, I think we'll start with Ms. Ng, and then the three of us, Mr. Sadek, Ms. Morris, and myself, and we'll invite. What the intent is to come up with a schedule, and we can get together. We'll put it on the website, let everybody know what it will be. There is no document other than the white paper at the present time and the existing rules. Those two are going to be the basic documents that we will look at. We have learned a lot in this year about operations, and we need to see how we can adjust to those operations from our perspective, approving agreements and keeping track of things and defining what needs to be defined better than we had an idea at the beginning. And we really have learned a lot. And so with that in mind, I'll just designate that committee at the present time to start, and we will coordinate with Ms. Ng Lee, and and I'm smiling because her contract is up at the end of August, and I suspect that this will be an item of negotiation when we continue, but I expect her to be continued, so we would keep going, and we would coordinate on a schedule. My own thought on schedule, we're early in June, and I don't know if we could get to a June meeting. I know what my schedule is, and I know what Lee's is, but I also need to ask about telephonic communications among committee members, and I know that there's been some legislation that has passed about communications using telephonic means. And Jim?
Well, this committee can meet by telephone or in person with or without notice until it begins to develop a product. But as in the past, I know that you intend to have public hearings and things like that, but the development of the product that goes out for a public hearing or public meeting can be developed however you all choose to develop it. What you can't do is involve more than three. Well, you could involve four, but I would stay with three.
Okay.
And, you can develop the documents.
I think everybody was familiar with what we did the last time around, that we scheduled meetings. We used facilities at TCQ mainly, and we had permission there for people to call in and participate by phone, and I think that worked really well. A number of the people here were participating, and they participated in all the meetings. That worked really well. We're going to need input from TCQ, of course, to make sure we coordinate with them. And Richard, I assume that you guys will be involved too because of the shipping and transportation stuff, and right? So, and maybe even Trav would condescend to somebody there, because they're a group that we haven't talked much about that may be able to also participate or figure out a way to do this. And so my thought is that later in the month of June, we would send notice out and try to give people, we'd communicate among ourselves and try to schedule a date where we would congregate for those who could or assemble by telephone to be here to talk about the project and then undertake the project in parts or in whole, however we want to do it at the time. I don't have a fixed idea now, and I'm telling you that I don't. We do know that we've got the white paper to discuss, and we've got to review the rules, and we've learned a lot, and we may invite, but our goal is to invite those of us who are actively involved in this process and now have been, to say, how can we fix it? How can we improve it? How can we make it better? How can we make it run more smoothly? So basically, that's what I wanted to do on item 7. And
there's also the export rule, Mr. Chairman.
Yes, it's exportation and importation, and we would consider, well, actually there's the three rules, the 21, 22, and 23, all of them are involved in this notice, and we would look at, I would think, all of the rules.
I believe so.
And see how we need to adjust, what we need to do to make them work, as I said, more smoothly, so we keep up a little bit better. So are there any questions about what we're planning on doing? And I figure the people from, I know that each of us involved, Linda and I and Dick, will probably be hearing from a lot of people separately, and we realize that. So I think everybody has our contact information. If you don't, Karen.
Hi, I'm Karen Haddon for Seed Coalition. And as you move forward in this process, I have a request, especially having heard some of the conversation here today. I know you mentioned keeping track of things, and I think that's really important, and I'm happy to see what has been done. I know Ms. Ng worked extensively to get some tracking systems in place, and I think that was a vast improvement. From the public perspective, I want you to know that we're seeing an increasing problem with obscurity and with difficulty in tracking things. And I would like you to revisit during this process, if you can, the forms that are being used. And while I understand that when you're doing an allocation, you can't get the detail that you really want about a shipment per se, I would like to ask you to expand the forms. Clearly, other compacts are using more detailed forms for their applications. California, when they responded with their application, they provided automatically a whole series of information about radionuclides possibly present and their half-lives. So, I mean...
If I can interrupt you, we're talking about establishing the process, and we're going into
right,
the details.
Right, but
and I'd prefer to save that for the discussions of the committee.
If I can make it brief, I would like to put that on your radar for discussion. And the point is that it is increasingly difficult to track these materials. And the other part of this is that you should know that I did ask for some of the manifests and have looked at them. And maybe I'm missing something, but what I'm not seeing there is any connection to a generator, to anything that you have approved. And so there's these big gaps in the chain. And in terms of public accountability, there's some major links, and I'm hoping that those will be discussed.
We recognize that matching generators and shipments is one of those things we probably end up talking about.
Good.
And,
that sounds good.
As far as the individual radionuclides are concerned, that's going to be a technical discussion primarily because I'm still not clear which individual ones would require attention or why, or whether we ought to just look at curies. And I know we have to look at the different half-lives of the different radionuclides, but some are clearly going to be more important than others. And that's the reason we need the technical people to give us some help on that, okay?
Right, and the lumping together of Class B and C has been most difficult. And now if we have WCS talking about considering decay, that becomes a nightmare for the public. Thank you.
All right. I think that's issue number 7. And again, those of you who are familiar with what we did last time, we'll get together, schedule a couple of meetings, we'll get together and talk about it, then we'll go away and write things up and come back and have another meeting or two, and it'll be a process that'll go on for probably a few months. Then ultimately we will make a determination at a future commission meeting of whether or not rulemaking is required, and if so, we develop the language for the rule, publish it as a proposed rule, have a rules hearing, and go through the normal Texas statutory requirements for such things. Okay? All right, that's 7. I'm going to propose we take a short break for a minute so everybody can wake up. So we'll be back at about 11:15. 11:15.
I am going to provide an update.
They're different. They represent but I would think it's reason why I think it would be good. But what's going to happen
Next week, maybe early, but I'm thinking we are What? She's trying to keep you straight. That is always
That's the bottom
It's crazy. Talk about stuff. So, you were talking about Dave. Well, you're going to be gone all week the 17th, aren't you?
Yeah, I'm going to be gone in Denver. Yeah, I'll be in Denver for that talk. I talked to them saying they'll be gone too. I will be back. I'm making it. I can't come back sooner, but I can definitely come back.
Yeah, I was thinking back in here sometime, 26, 27.
I have nothing going on either one of those days.
Yeah, and I think next week will be a little start thinking about it.
It's too early for me to start.
Yeah, it's too early for me to start thinking about it. Next week, I'm going to be in Galveston for 3 days ago, TFCA meeting.
So what we're going to do, if I heard you correctly, I'll fly to Vermont, have a meeting, and we'll meet with Dick in Vermont.
That's exactly what I said.
Yeah, that's what I thought I heard. That's what I thought. I'm sure.
I did actually, we probably at some point along the way will have one to have
Like either plug in or go dance out here. Either one. Either season.
Why don't we
Okay, no, I will block the whole day for that.
And initially, this initial thing was to go figure, figuring out dates, that sort of thing, figuring out what we want to do. That's where it's going to develop. I know you've got a list of issues that you probably should talk about.
Yeah, I've got a list of part of there's others that we have that we should get the three out.
So why don't we do this? Why don't we on the 28th, but in the meantime, if anybody has anything they should so if they want to be, maybe they should let you know.
Yeah, like for instance, because I know like with John, having to do the technical summary, he's got a whole list of things he hates about it. So, you know. Yeah, and we have some things on there, we just have a blank for us to put in a number for it. And some of it's little, some of the whole thing about IT stuff, I'm making them out, maybe making it more, the things that we don't hard to look at it. And then we don't even do FEC. I mean, the whole idea is take it in, about 3 minutes and point out the program for the first year. Make it work because the rules set,
what isn't in our rules that we might want to?
There's that list too. There's that list. There's that list.
So Karen, welcome to you.
You got here just in the nick of time. All time could not be better. So this is good. This is a really good time to be speaking. This is about when I got involved in it a year ago. Sorry, a little over a year ago now when we started being involved in that software training is critical.
A lot of it's practical. Things that had to be done.
Oh, yeah, but yeah. We had a contract meeting next year after that.
Just wondering why that's in our Well, if that's in our bylaws, let me talk to Dan, perhaps in our current. Yeah. There's conflict in our bylaws and conflict language on the scope of the audit that is to be added to the auditor's cost. Generally accepted governmental accounting standards is what's in our bylaws.
I still think it's very good. I went to I like it. I've never been to those are when I was I it's all good.
Audit reports should be made part of the report.
And did all that, and often, there's no such call, not that I had that thing.
Right.
It says, language in our bylaws requires more extensive work than just checking the And therefore, he's got to do more, and he's got to see how much more time, how much more $500, not a problem. And I'll build a commission. I'm sure that I've got the authority to authorize you to go ahead. How much yeah, there's just one more. I've been with that. I'm going with all process.
No, you didn't. You didn't like it.
All the invoices should be there, because, well, most of the invoices on the bank statement were wrong. On the bank statement, by UPS stores, by Verizon, and telephone. Probably authorized to do that again, although I don't think it was authorized. I wrote a couple of checks to her own bank account, but that was after I was in chair on the mic here a long ago. I don't know about
They would not have had the records to maintain its violation before the order started. Well, they're in those files. That's right. And most of we never wrote those Okay. Well, go ahead. No, send us the okay. Which address? Thank you. Jim's saying the only thing they had was official stuff from the board of financial statements. They don't have these. He's got a most of the until
We'll start resume the meeting and go on to some actual amendments to import agreements and that sort of thing. And But before we do that, Dick, during the break, Linda and I were conferring with Lee about our little committee that got organized, and we've decided to have just a general discussion meeting, which we can do telephonically, on the 28th of June. Would that be at your convenience?
I think that's okay, yeah.
You could call in.
Yeah, I'll let you know, but I think that's okay.
Okay. For those of you in the audience, what we're planning on doing on this committee is having just a organizational scoping meeting to set out the framework and try to come up with some dates to schedule public meetings and discussions. But we want to particularly invite everybody who's involved, TCEQ, anybody else, the generators, brokers, of course WCS, to start thinking of suggestions to us on the rule, our existing rules. What?
Yes, yeah, rules.
Rules. On our existing rules we have in place. If you see a need to make changes, you can communicate those. My preference would be that you just submit them to Lee Ng at the Compact Commission, and Lee will consolidate them, and then we'll get them down. We'll take that paperwork. Among us, my idea is we may establish, it might be difficult for us to establish a call-in number for that meeting for a large scope, but we'll see what we can do. We'll work on that. On the 28th, we won't know a time yet, but the idea is the committee will get together and talk about what we're going to do and the way we're going to be doing it, and so we don't have to involve anybody, but we want to let you know that that's what the plan is. And from that time forward, we'll try to give a little bit more defined times, dates, places, so everybody can, if we have to have some public participation, we will. And we do want your suggestions. So feel free to write in anything you think we could do to improve our rules. Okay? All right. And that's the last one, item 7 then. And next, item 8 is 8A, consideration and possible action on each of the following requests for amendments to agreements. First one is PG&E. This is Humboldt Bay, I assume. Is that right?
Yeah.
Are you going to take care of this for us, or is John, are you going to do this?
I'll take care of this, I guess. Okay. We received a license, or I'm sorry, an amendment request from PG&E Humboldt Bay Power Plant, and sort of to summarize, they had an allocation for year 1 and year 2. However, I guess due to some various issues, they were only able to make one shipment in year 1. However, by the time that shipment arrived at the facility and was accepted, it was year 2. So the shipment was actually made on April 11th, but it didn't arrive and be accepted until after April 26th. So it needs to be accounted under year 2. So what they are asking is basically to transfer their allocation to year 2, if you will. The specifics are they want to go from 601.5 cubic feet to 1,000 cubic feet, from 2,800 curies to 3,000 curies, for carbon-14 from 3,071 millicuries to 3,291 millicuries, and for technetium-99 to go from 21,612 microcuries to 23,155 microcuries. So in essence, all the waste that they will dispose of under their import agreement will be in year 2.
Okay. Another question I have, does this mean that did they have a separate agreement for year 2? And
I think it was really just one agreement that was going to extend between year 1 and year 2. They have one agreement. Okay. It's just, in essence, all the waste under that agreement will now have to be disposed of under year 2.
And to further go back, year 2, we're meaning operational year 2, which goes away on September the 1st, theoretically.
Theoretically, yes.
Okay.
And
Yeah.
I believe that under that agreement, the expiration is April 26th of 2014. And they, I don't believe they've requested an amendment to that date.
Okay, so we would basically then have an agreement with them to import quantities that you described, as long as the agreement termination date would be
currently April 26th of 2014.
All right. Yeah. Then we wouldn't care during that period of time when they shipped, I suppose.
No.
All right. Are there any other questions of any of the commissioners about the PG&E Humboldt Bay? Does anybody else in the audience care to make a comment about it? Nobody wants to? That's great.
Shall I make
what's your recommendation then?
I recommend approval, and I make a motion that we approve the amendment request, which is 1-0028-01 for PG&E Humboldt Bay Power Plant to increase their volume to 1,000 cubic feet, the total radioactivity to 3,000 curies, the carbon-14 to 3,291 millicuries, and the technetium-99 to 23,155 microcuries, with no other changes.
All right. You make that motion?
I make that motion.
Is there a second?
Second.
Motion's been made and seconded. Is there any discussion among any of the commissioners? Hearing no discussion, all those in favor of the motion say aye.
Aye.
Any opposed? Motion passes. Next, item 8V is Phylotechnics, and tell us about this one.
Let me get it open.
Sure.
This is an amendment for a increase in the radioactivity from Phylotechnics from 800 millicuries to 1,600 millicuries. There are no other changes requested, no change in the volume or the types of materials that would be disposed. And I've read through so many of these, I can't recall exactly why they need the increase. Lee, can you help me?
I can. They need the increase because the amount of curies in the waste, once it was tested to get ready to be disposed of, was more than they had originally estimated.
So the change is from 800 millicuries, so basically 0.8 curies to 1.6 curies. It's not what I would consider to be a significant increase in the curies, and
it's not much to start with.
It's not a lot to start with, and it's no change to the volume or the kind of waste that they would be sending.
Good thing we're not talking about it on a percentage basis. So, any questions of Mr. Salter? Any further discussion among the commissioners? Any comment that anybody cares to make about this application? Hearing none. All those in favor of the...
Actually, I don't think I've actually made a motion.
No, you haven't made the motion. I'm sorry. Thank you. I'm just running ahead of you.
That's all right.
You did so well.
You're keeping me on track. I make a motion that we approve the amendment request for Phylotechnics 1-0025-01 to increase the radioactivity to 1.6 curies.
We figured you were headed in that direction.
I understand Dick seconded your motion. Is there any further discussion on the motion that Mr. Sullivan just made? Hearing none, all those in favor of the motion say aye.
Aye.
Any opposed? No opposition. The motion passes. That's item 8. Next on your agenda, item 9. Consideration of a possible action on each of the following applications: proposed agreements for importation of low-level waste. The first one, A, is Bionomics 1-0032-00. John.
All right, the technical committee has reviewed the application from Bionomics for a permit to import waste. That application was officially received by the Commission on May 1, 2013. It was signed by the applicant Bionomics on April 26, 2013, and the number, as you have stated, is 1-0032-00. Bionomics proposes to import Class A, Class B, and Class C sealed sources that would, in fact, be encapsulated in concrete. We do have letter correspondence from TCEQ dated May 7, 2013, which approves the compact waste facility operator to dispose of that material. Bionomics is proposing to import 52.5 cubic feet, 196 curies total, 200 millicuries of C14, 200 microcuries of technetium-99, and 500,000 nanocuries of I-129. That volume in cubic feet is not significant in terms of the current limits of 120,000 curies and 50,000 cubic feet for the second operational year. The waste they are proposing to import will be from a long list of states: Alabama, Arkansas, Florida, Georgia, Illinois, Indiana, Iowa, Kansas, Kentucky, Louisiana, Michigan, Minnesota, Mississippi, Missouri, Nebraska, New York, North Carolina, Ohio, Pennsylvania, Tennessee, Virginia, and Wisconsin, which are members of the Southeast Compact, the Central Compact, the Central Midwest Compact, the Midwest Compact, and the Appalachian Compact. And there are some unaffiliated states in that group as well. Of those, only the Central Compact requires an export authorization, and I believe as of earlier this week, the Commission has not received authorization.
That's right. In discussion with Bionomics, we would potentially want to put a condition in this agreement, if y'all chose to enter an agreement, that waste from the Central Compact could not be shipped for disposal until that authorization from the Central Compact had been received.
And just, I believe the way the Central Compact does their authorizations is they actually publish a list of generators who are authorized to export waste. Isn't that correct, Lee?
They do. They have a list that they publish on the website, and they also will give documentation individually. So we could either look on the list or the generators who provide us the individual documentation.
And that waste, by the way, is the Central Compact, and that's from Arkansas, Kansas, and Louisiana. Those are the only states of the list that I read that are subject to export, the need for export authorization.
Okay.
In addition, Bionomics has requested that this waste be applied against any sort of small quantity generator set aside, and based on the volume and curies that are requested, I think that would be appropriate to consider it from a small quantity generator. In addition, I'm not aware that Bionomics has access to any other waste disposal site for these materials. And then finally, Bionomics has requested their volume and curies in a multi-year agreement, but they require at a minimum 1 year. So I don't know exactly how we would want to treat that. I suppose we could authorize them till April 26th of 2014. However, we'll have that date change on September 1st that I'm still somewhat unclear as to how we'll handle that. I don't know that they can get all the materials in by August 31st.
Of which year?
August 31st of 2013.
Perhaps they can, I honestly don't know.
That may be the case with many of these.
Could be the case with many of these.
The situation I think that you're in is that WCS has acknowledged that they are only authorized this amount up until August the 31st, and so to the extent they, I guess to sum up, I think April is the right date, based on the way you're doing.
Roll over. Yeah, would it make sense for us just to authorize it right through August of 2014?
That makes the most sense.
If we
I didn't mean to propose it.
You didn't mean to.
No, but
That makes the most sense from the staff standpoint.
we've actually had discussions locally here about just those kinds of issues, and one of the oddities that took place at the time we were having the discussions is that we were not yet sure that we were sure that it passed both houses, but we had not yet seen that it had been sent to the governor for signature, and it still isn't law. So it won't be law until it becomes law without his signature or he signs it.
What's the last day the governor signs this?
16th.
10 days from now. And so then it would not go into effect until September the 1st. So we're sort of playing with something that we think will happen. But it makes sense administratively, and there's nothing to prevent us from authorizing a date that expires August 31st of 2014, if that's what we choose to do.
Bob, I would, from a practical perspective, if we chose to do that, I think in terms of the accounting, if you will, what we would probably need to set up is that we would get a report that would indicate for any importation agreements that we have that are in effect, we would need a report shortly after August 31st that would indicate here's how much was shipped, and we could then go in and if you will, reduce the allocation for any active import agreements by the amount that was shipped by August 31st, so that we can begin properly accounting for the 275,000 curies between September 1 and August 31 of 2014. Sorry.
Yeah. And
They'd have to provide the report.
yes. And we do get information from WCS of what they receive and dispose of. And so do we get that showing by generators, or do we just get a quantity of curies in this amount?
We're provided that information by generator and agreement number.
Okay. So then, if we're provided the information, it ought to be a simple accounting task, because they will tell us when material came in under a particular agreement of a generator, and we would know, and we'd be able to just count, I hope.
I can manipulate the spreadsheet to do that.
Okay. All right. So,
Well, I'll turn that into a motion then. I would move that we grant permission through August 31st, or we do whatever's necessary to sign a contract.
2014?
2014.
All right.
So,
John?
shall I make a motion that incorporates that as well?
Dick made the motion, and I assume one of the things that could happen is you could make a motion and Dick could second your motion with that.
Well, how about if I make a friendly...
I can withdraw my motion.
Start over.
Or I can make a friendly amendment if you'd like.
Start over.
All right. Well, I recommend approval and I have not received comments from other members of the technical committee, so I recommend approval of an agreement with Bionomics Incorporated. That would be 1-0032-00 for a period beginning, I guess, April 27th of 2013 through August 31 of 2014 for a volume of 52.5 cubic feet, 196 curies, 200 millicuries of C14, 200 microcuries of technetium-99, and 500,000 nanocuries of I-129. Did I say that one twice?
All right.
The waste form is stable. The waste classification is Class A, Class B, and Class C. The waste description is sealed sources. The states are Alabama, Arkansas, Florida, Georgia, Illinois, Indiana, Iowa, Kansas, Kentucky, Louisiana, Michigan, Minnesota, Mississippi, Missouri, Nebraska, New York, North Carolina, Ohio, Pennsylvania, Tennessee, Virginia, and Wisconsin. And for the states of Arkansas, Louisiana, and Kansas, that we not authorize any shipments of materials until we receive authorization from the Central Compact that those materials can be exported.
Correct. So it's contingent upon Central Compact.
Correct.
All right. Complicated motion.
Sorry.
Is there a second?
I'll second that.
All right.
Having withdrawn mine.
Well, yours was simpler.
Yeah, but his is more accurate.
All right. Is there any discussion among commission members on the motion? Anybody care to make a comment? Seeing nobody commenting, all those in favor of the motion say aye.
Aye.
Any opposed? Motion passes. Bionomics application is approved. Next, Biotechnics. This is application number 10033-00.
The technical committee's reviewed an application for Biotechnics Limited. That application was received officially by the Commission May 1, 2013. The original application was signed April 30, 2013. It was revised on May 1, 2013, and then it was further revised on May 23, 2013. Of note, Biotechnics is a waste broker who is also a licensed waste collector, and they're requesting authorization to dispose of non-party low-level waste. Unless something has been received recently, we have not received from Biotechnics signed generator authorization document. So that's one of the documents that we require, is that if Biotechnics is going to broker waste, they have to have a document from the generator saying we want Biotechnics to broker our waste, and we have yet to receive those documents. Ms. Ng.
We have it from one generator, Stanford.
We have it for one generator?
For one, Stanford out of California. And we also have the export authorization for that one generator.
So for any agreement, if we chose to approve one, it would have to be subject to generator authorization documents and any export authorizations if they would be required. The Biotechnics is proposing to dispose of Class B and Class C unstable sealed sources, and we do have letter correspondence from TCEQ approving that, dated May 7, 2013. They are proposing to enter into an agreement for 100 cubic feet and 15 curies of total activity. The amendments had to do with the state's that they are proposing to take waste from. And what I will do is just read you the final list, because that list changed over time. But that's from California, Illinois, Indiana, Ohio, New York, Arizona, Oklahoma, Arkansas, Louisiana, Mississippi, Alabama, Georgia, Florida, North Carolina, Virginia, Tennessee, Kentucky, West Virginia, Maryland, Pennsylvania, Rhode Island, Wisconsin, Michigan, Iowa, Nebraska, South Dakota, North Dakota, Kansas, Missouri, New Hampshire, and Delaware. Representing the Southwestern Compact, the Central Midwest Compact, the Midwest Compact, the Central Compact, the Southeast Compact, the Appalachian Compact, and several unaffiliated states. So any generators from the Southwestern Compact and the Central Compact would need to provide export authorizations, and as Ms. Ng has indicated, we only have it from one generator, Stanford. In addition, Philotechnics has requested that the waste be disposed of under a small generator allocation, and based on the volume and curies, I would agree with that. In addition, I'm not aware that they have access to any other waste disposal facility, and they have requested a authorization for a one-year period from 4/27/2013 through 4/26/2014. However, based on our previous discussion, I would recommend that we change that to August 31 of 2014 to be consistent.
Okay. Anything else?
That's all, and the technical committee recommends approval.
All right. Discussion. You're ready to sit.
I noticed that they don't check any radionuclides. I take it that we're just kind of taking their word for the fact that there are 15 curies and that they break down however they break down.
In this case, I believe the sealed sources that they intend to dispose of do not consist of carbon-14, technetium-99, or I-129. So by our forms, there's no need to provide information with regard to the specific radionuclides. I would say we've received other applications that are similar to this that haven't specified the radioisotopes because they're not one of those three that we ask about.
I have a question. If we approve these, and just for my information, conditionally on their getting approvals from the compacts or the letters from the generators that they're authorized to act, how do we communicate that we have or do not have those with TCEQ or WCS?
How do we communicate that we have the authorizations, the export authorizations to them? When we send out your letter, the letter that you sign that confirms to the company that we've received the authorization and therefore that condition has been lifted, they get a copy of it at that time.
What we do, Mr. Chairman, is we'll write a condition in the contract, and it will be subject to approval to your satisfaction that they've got the authority.
Somebody walk, get up and move.
And then once you get that, that goes to WCS and TCEQ.
I'm guessing. These rooms are motion sensitive. Maybe not.
Here we go.
Thank you, Audrey. Thank you, Dan.
Everybody does their part.
Local Waste and Compact Commission managed it. So immobilized.
Generators don't like that.
What that says is there's a bunch of cadavers in here. Nobody was moving.
Well, I don't know where we left this at. I hate to be the paper police, but why don't they have these done before they bring them before the commission?
I'm merely the messenger. But to a certain extent that you could potentially say applications such as these are speculative. In other words, they don't have the contract for these sources, so they don't have the authorization for exports from these sources because these sources may go ultimately through another broker. And so they haven't secured authorizations. I mean, that might be a question that would be considered by the committee doing the import rule, is to what extent do we want to encourage or not encourage speculative applications for sources? How important is it for just to ensure sources are disposed of, and where we would want to accommodate that or not? But that's what you're seeing here, is not all the contracts are here, but if they have approval, it may make securing those easier.
So, for example, they obviously have approval from Stanford.
They do.
But to date, Lee, we've not had any that at the end appear to be, well, they may have been speculative, but they've all come together, right? In other words, we've not had any that have, where we have dangling.
Where we leave an identified generator on an application, they never get the paperwork from that generator.
Yeah, we have had that happen actually, but that means they don't ship.
Right. Huh?
And those applications have expired where we've done that before, and the sources were never shipped.
Well, you're right. This is going to be a good topic to talk about in connection with our discussion about the rules, because
I think it's a mathematical nightmare trying to keep up with who's in, who's out.
it is.
It's a little bit of a, it's more work trying to read through the application and figure out what's the final version of it as well.
I'm looking forward to hearing your motion on this one.
I'm not ready to make I guess I would say this one does appear to be very speculative, and to me that's perhaps somewhat concerning, and I think it does create perhaps some real administrative difficulties for Lee and Audrey to try to keep track of who's in and who's out, and I think it can be somewhat complicated and perhaps create the possibility that something would get missed simply because of there's so many pieces of paper associated with it.
I just wondered, because I do listen to what she says some, you know, I don't know, but I'm for the Southwest Compact getting Stanford taken care of today, but it bothers me that these companies are just throwing this stuff at us and not being, and really this comes from Commissioner's Court, it doesn't come from here, but you get all these people want stuff and then they never have, and you get to court and we've got a contract Monday that's not even there for the commissioners to review yet. And it's simple, it's a 3-year contract between the chamber and us, but it's still the same thing. I mean, if they're going to be in the business, they need to be in the business. And I'm for Kathy, so.
Kathy?
Kathy Davis with the Southwest Compact. I agree that some of this application is going to put out so much, and then they go out and get the business. It's a little bit backwards. I'm not sure if they feel that your process, they're not comfortable with, the timelines and how it works, and then they go out and gift the business, and while Thomas Gray has seemed to have gone out and got the business, and I have a number of petitions from them on hold sitting in my office right now that I've approved, but they're not ready to ship yet, so they haven't filed the application, but they've done this a couple times, and so they're familiar with the timeline and feel comfortable that you are, in fact, accepting them. Because, a lot of this has been questions of how much will you accept, and what's the small generator going to participate. So perhaps reviewing this and questioning their process, and I can as well call them and talk to them about this, that you really need to have a little bit more than just, I'm guessing that this is what I'd like to do next year versus this is what I have in line. Although I do know that they're working with Impact Services, which is the company that went bankrupt. And so a lot of the things they have there might be coming up that they're trying to process and go through barrels one by one and doing an inventory, and maybe they're speculating they're going to have some need there. I'm not sure. I haven't talked to them about that. But I could understand why you would look at that. And Thomas Gray seems to be doing a system that's working for them, where they'll send in, they have the customers, they have the commitment. And but then I don't know if Polytechnics has a holding place where they can go pick up and hold as much as Thomas Gray does in California, where Polytechnics deals across the country, and maybe they don't have a holding place where they can go around, do pickups, and hold it till they get an adequate amount for shipment. So those would be the types of questions we'd want to have to ask them.
And just to sort of bring it up now, this will come up again when we discuss Sacramento Municipal Utility District under D. They also do not, they're from Sacramento, Southwest Compact, they also do not have authorization because they're not 100% sure they're going to ship this year or here. And again, it's just one, so the paperwork is a whole lot easier, but it is somewhat speculative.
Yeah, Rancho Seco. What was interesting is I saw them coming up. They had the application and number signed to them. Contacted him through email. He had an incorrect email, so we called. Both of us were calling him. He came back to me and he said, well, I know I need a petition, but I'm not really too sure if I'm shipping this year. Because I was all ready to, get it in last week before we had the meeting. And with that comment, it was like, well, what are you doing this for? Well, we're not sure what our schedule's going to be. So again, their attitude is, well, let's file it and have it ready, and then if we meet that date, oh, good, and then we don't have to, we'll be in that timeline. Where like PG&E, you can see what happened to them is that, they had the best intentions to ship, and they missed it by a couple days by the time, and a lot of that is, how they process and how, their delivery dates and whatnot. So, but that it will be a good thing for you to discuss in your rules and maybe have some or assign a money value on the Curry limits that they're asking for, pay up front type thing, or this is a timeline you need to be committed to thing, or you have a penalty or maybe just even an application fee, so that there's something that they've put out there that's cost them a dollar amount, and so that they're not as likely to just be filing this paperwork, because it is a lot of paper. It's a lot of paperwork for me too.
Where I see this, Mr. Chairman, and Kathy and the committee, is when it goes what I call into the box. We don't have that anymore, and these guys are sitting out there speculating if they're going to use it or not, and it's depriving somebody else
that might have ready shipment. Exactly.
Plus, my county and the legislature of this state that's tax dollars or money coming in that's not there, that's a ghost place, and I can pretty well guarantee I'm totally 100% of this, and any of my legislators are probably going to say the same thing, is that this is not a good thing for the state.
Right. So, and again, this has been a learning process for everyone in how to establish import and export. If you were even going to be doing that for non-party states, in the beginning, that wasn't really
rules that you couldn't. You had to be ready.
Right.
With the Sea Coalition and all that, it was. The paperwork was here and all that, and
so
we could document it and WCF keep up with it and all that.
But. No, and I'm sure that, from my perspective, and you're executive director, you don't want to be spending time.
I got a report about how much revenue that we're going to have to budget next year from WCS, and it may be this, and it may be this, and a lot of this is involved in that, so.
I totally agree.
And I'm speaking to the choir captain.
It's going to be a learning process, and something to lay out to the companies so that they have an understanding what their obligations are. Because it is a dollar issue with you. It is a matter of what you're expecting to come into your facility, and why would you want to give up for someone else that's in line that's ready to go. And again, so you need to look at your rules.
Somebody else like
Stanford, well,
I mean, you're
right.
letting Stanford write the letter, get all the stuff, and then you're coming in behind them. And you're not ready, but Stanford was, so you're jumping on that contract and kind of going out around the rules. I'm for Stanford today, but I'm really not for the rest of them because they're not ready.
Because they don't have everything. Right. And that,
when this happens, somebody applies in 1 year, let's say they ship 2 years later. They've applied for a certain number of curies. They ship 2 years later, so it's decayed somewhat. They're not
talking about that on the airplane.
They're not going to want to pay based on their application. Right? They're going to want to pay based on the lower.
They'll pay based on what they actually ship. As I'm relatively confident that's how WCS would handle any contractual arrangements based on what's received at the site.
A lot of times in their applications they do overestimate. And some of that is because of some of the past compact history, where if they ship to a facility and they've underestimated, they get a penalty because, well, you didn't give us the right number. So they're a little paranoid sometimes about, well, let's do it a little higher so that I know I have a buffer. But when you did like PG&E, you gave them a time period that was longer than normal. This would normally your contracts are from a set year, but now it's going to be a fiscal year. And now if you do a longer agreement, well, then that's going to be a case-by-case basis if you're giving them utility company, say a 3-year agreement or something. So, and we've done that in our compact where we've had utilities have done a major closing down or decommissioning. We'll give them a 2-3 year petition so that they're not constantly coming back renewing things because it's under the same project. So.
We did that to Exelon and Energy last week.
Yes, sir. Dick.
Oh, sorry. This is a dynamic between regulatory commissions and companies that it constantly takes place, where the companies want to reserve something and maintain their flexibility. And it strikes me with this commission that we meet, roughly 5 or 6 times a year. We meet quite a bit, and we're quite accommodating to, and we have a lot of, well, we've got a lot of curies and a lot of cubic feet to deal with right now. And I don't think, if I understand this issue, maybe I don't, but I don't see any reason that we should accommodate to the extent of saying, okay, we'll wave it through and you guys do what you want to do and see what you can line up commercially and so on. I mean, if we met once a year, that would be a little bit different. But we are, we make an effort to react when we get petitions, and we do react. And I don't see any reason why we should issue, what amounts to a kind of a blank check on this kind of thing. I think we should require that, and we have in the past asked whether they have permission from their respective compacts, and when they haven't, we've deferred the application, or said we're not going to pass on it right now.
Dick, I think I would agree with you as well.
have a question. I noticed, John, that a lot of these sources are part of the SCATTER program, the Source Collection and Threat Reduction Program. It's my understanding that a lot of those are going to be going to Energy Solutions in Clive, Utah, that one-year window for sealed sources. So it could be possible they might not end up sending them here.
It does appear to be somewhat speculative,
yeah.
And I think after hearing the discussion, I think I would probably be more inclined to provide them an import permit for the materials that they have authorization for currently, which, if I understand correctly, would be the materials from Stanford.
Mm-hmm. That's correct. I'll just mention that the one you just approved before allowed waste to come in pending authorization from the Central Compact, that being Bionomics. I just mentioned that from a consistency perspective.
Nobody ever said we were consistent.
Never had to be.
And I'm not saying you need to be consistent.
And I believe Bionomics has indicated they have a list of generators, or they've provided that, haven't they?
Yes, we have that list, and they maintain
The
it.
difference is their group was much larger of people we already had permission from. There were a small group of people that we didn't.
Right.
As opposed to this one, where there's a whole bunch of people we don't.
We don't have any information for the vast majority.
They don't. They didn't submit a list of even companies with this application. Just Stanford was the only one. Interesting. Okay.
Well, I'd like to give a signal that, and I think maybe this is the one to do it on, is give a signal in the future. Get your permission before you come here. We're open for business a lot of the time, and it seems to me that is the sort of requirement that makes sense. And the judge has certainly pointed out the practical problem with that.
Dan.
You're going to change the rule on that?
No, I just wanted, Dan Burns with WCS, and I just wanted to offer a couple perspectives. Ideally, these folks would be, here to present, so they could, and we're going to make sure as WCS interest, we'll try to get the folks here that are making these petitions. We'll put some more energy into that because I think that would help the conversation, obviously. And I think that a couple things I just wanted to mention, with respect to this phylotechnics thing, we are talking about small quantity generators. And I think, as you're aware, most of this time this is what we've called in the past as aggregators. So he's got one drum filled with literally dozens of people's waste. So that there's a natural efficiency and a consolidation and things of that nature that occurs with those folks. So to some degree there is some speculation. I got enough committed to fill half this drum, but I'm going to try to get some efficiencies and work with other customers, other universities, other pharmaceutical companies and things of that nature. So these brokers and aggregators, we do have to understand the kind of customers that they have. It's just every university in the country. It's every pharmaceutical company. They're doing a service for us as well, being this aggregator as well for all these, what we call small quantity generators. So there does seem to be some, we should have some recognition, I would hope, for that problem that they have, because they are taking those cups and put them into one. And sometimes with the temporal issues associated with submitting by the first and everything, and I'm not trying to defend that, the timeliness of anything, it does put them in a position to be more speculative. So they, Stanford has a 10-gallon pail. They're talking about putting it in a drum instead of just sending a 10-gallon pail to us, which is a little bit difficult, to be frank, because the paperwork alone may be more than the unit rate. The volume is there. So that's part of the give and take and the value that we have. So I'm not advocating anything. I just wanted to bring up, especially with respect to Bionomics, Phylotechnics, RAM, and Thomas Gray, and all those folks. We need to like to continue working with them, but there has to be some expectation that they can't, they don't have a drum sitting there that they submitted an invitation petition for. If they do that, it may be very problematic to move those sources out of those places that they shouldn't be. You know, it's much safer in the hole in Andrews than it is in a university basement and things of that nature. So I think that's part of the dynamic of what you're seeing about the disparity and the types of things that Kathy was talking about. So, and I guess for thought, you know, there may be, I think the idea of the conditional approval is, I think the way the rules are written today, it satisfies everyone that, you know, you have the right to put a condition or a term in any of these agreements to be able to approve so that they can plan and go get everything, and then we're assured that we're meeting the regulations and the intent and the purpose of the commission. So I think we may find ourselves with some, you know, need for a broad use of those conditions and things of that nature and some creativity there, especially in these instances. Again, it's another thing it's a complicated world. There's a lot of small quantity generators we're talking about. Like I said, California's talking about a can of seed. It's a paint can. And you see that kind of thing. And we want those things to find a permanent home. So again, I guess the thing I think is you know, potentially within the current rules and pending further analysis as we go forward, looking at the new ones, that conditional approval may be something that's appropriate. And then lastly, I would mention, thank for Mark coming up, because I think he might expound on something that I was about to say, is that a lot of these folks plan years in advance. And one of their decision criteria is to say, okay, I got a good plan. I know I can go embark on a $3 million project to generate and package this waste correctly in a year and a half now, because I know I got a home for the waste. So, I mean, you know, waste disposition issues are critical to some of these plans, especially for the larger generators such as Rancho Seco. You know, it's just, and that's what we saw in the legislation. By getting the Curies to be more consistent and stable, as you all talked about this morning, people can be more predictive. They can predict more, and they can be more confident in their plans. Because, like I said, some of these larger utilities, they have to spend millions of dollars up front to get those couple liners out to disposal, and that takes a lot of planning. So I think that's why you're seeing some of these things that you may consider speculative, because it's part of the decision criteria for them. And Mark can expand a lot better on that aspect of it, if he will.
So, Mark Carver with Entergy. I was promised my attorney I wouldn't say anything about Entergy. I just wanted to give you an insight to why you had on this previous Bionomics export permit, the Central Interstate Compact. They meet next week in Little Rock, and they won't approve their export permits for the next fiscal year until, or calendar year actually, for generators, which starts June 30th of this year to June 30th next year. They won't do it until they meet next week. So that's why you haven't seen an agreement for that particular one. That was what I was going to address, because I did promise my attorney I wouldn't say anything else. I'll just step away from the microphone.
But wait, we may have questions for you.
Well, that kind of illustrates my point. We meet 6 times a year. I don't know how often they meet. Did you say they meet annually? Or?
The Central Interstate Compact actually has Kansas, Louisiana, Arkansas, and Oklahoma within the confines of their compact, and they meet once a year in person, and they do have provisional phone call status as far as the compact goes, where they will meet by phone, but they give their executive director a lot of leeway and approval for export permits after June 30th face-to-face meeting.
And they don't do imports, of course.
No, they go to that annual meeting, get their permission, and then we'll see them in August or whenever.
Right.
I really think this is a problem that happens, as I say, all the time with regulators. And I mean, why don't we just wave everything through and and trust the shippers to kind of work it out, and the judge can go back and put an asterisk on every
I would say that you dig
on in terms of what the county can expect and so on. That seems to be a very kind of unsophisticated way to proceed.
I'll break into
companies, and they can, they make a lot of money doing this, and I don't know why they can't cross their T's and dot their I's before they come here.
I'm done, Dick. I just want to make sure, because I started to break in, I apologize. I was going to say, I remember coming to the last meeting and getting the third degree about how accurate my 2015 import request was, and would I really do it, and what assurances did you have that I would use it. So you did give me the third degree. I did try to answer everything, but obviously not all the generators in those small groups can make it to these meetings. And I promised Vice Chair Lee I would be here this week, today, and then he didn't show up, and he's not a member anymore. So I pointed that out to my attorney. The one thing that I'm going to bring up, I'm going to disregard what I told my attorney. The one thing I would think that I would like you to think about is that I have an import permit approved from April 27th of 2015 to April 26th of 2016, which crosses boundaries with the fiscal year that's been put in place. So that'll probably in your next in your committee meetings and your other meetings, I need to hopefully that you will shed some light on that and follow up commission meetings. Do you have any questions for me?
I'd be prepared to submit an amendment if I were you.
Yes, an agreement doesn't have anything to do with what, the agreement is what the agreement is.
If you tell me what to do, then I'll do it. I promise you I'll do it.
And I'm trying, this has been a fascinating discussion for me, because I'm hearing all sorts of things, and to me it all, in essence, this doesn't have anything about curious or capacity. It has to do with a couple of peculiar problems. One is, for example, we could solve this problem with the Southwestern Compact by entering an agreement between our compact and the Southwestern Compact to do things in a certain way. The problem is licensee. We have to have import agreements with generators. It's not enough that we have an import agreement with the Southwest Compact. We've got to have it with generators. And so, and Dan, what I hear everybody saying is that, okay, Stanford has a 10-gallon bucket or whatever of stuff that they need to ship. Whether they ship it, in fact, is a function of whether they can combine it with other shippers to an economic unit for shipment and disposal. So the brokers, the aggregators, to use that term, are going to be going out saying, okay, do they approach it from a concept of, I've got to have this quantity of stuff to ship before I know that economically it's viable, and if I don't get there, I won't ship? And how do they approach WCS for disposal agreements under something like that? Because you tell them, we're going to take it this way. I assume. I've never looked at your contracts. I don't have access to them. And I don't know how it works. And I'm trying to listen to the practicalities of what is involved, particularly with these small things like the scatter system and the seal sources that might come from everywhere else, and figure out how to make it work for you and for us within the context of these statutes. And I'm not hearing anything like that yet. And I assume we're going to get there when we talk about the rules.
Yeah, I agree with you. And just a couple observations. I did get a text. And it says, John is watching. Do you want him to be on the phone? That's McCormick. So McCormick, John's here somewhere. So I have a phone number for you if you want to do that. But I cannot answer the question about how they approach their customers. I can't answer the question about, the way we have a contract that extends over several years with them, and it contemplates, at the time of the contract, and we don't have to define the specific isotopes and things of that nature. And the reason we don't is because we put in, there's a condition, a term in all our contracts that says we have to obey with all our laws and licenses. So the customer understands that we have to have an importation petition. It's a block we check on every shipment. So when we do have the information to provide the detail to satisfy our license and the laws, we can do that at the time of when they make their shipment request. So we have 5-day notices and 3-day notices and things of that nature. So again, what we have is terms and conditions that allow us to enter, get the broad base done, so that these companies can go out and say, I do have a contract for disposal, and establish credibility with Stanford. But we know we've got work to do at the end too, when they do have the definition. So, and it's just a part of what these folks generate, and when they generate it, and when their budget cycles are, and all that kind of thing too. So I could not tell you how the brokers actually craft their agreements with folks, but I would assume just by the evidence of what we get, that they do assume some economic advantages due to this aggregation process to compete with one another.
And I'm assuming that there's a minimum quantity of something that they have to get together and have contracts for, or they don't ship to you. And so when they come in and ask us for import agreements for such people, they may or may not know whether those people are going to sign up with them for the agreement. And so, Judge, getting back to your point, how can we possibly forecast under something like this the revenue or the volume of the curies? Because we don't know. We have always assumed that when we approve an agreement, it's for somebody has a definite intent to ship that quantity of that stuff. And what we're now learning is maybe that's not true.
I don't know. I just know the legislature, the talks I've had with any of them, is that we're doing this for a reason, and those reasons are for revenue, and that's reasons that we need to have, one, health and safety of Texas and the nation, but secondly, if we're going to do it, then we need to be paid for it. And two, I'm sitting here looking at Lee. I counted 31 states on this one deal. We got 2 hands. And those states got 31 hands, or at least doing that paperwork. We have 2 people, probably 6 FTEs, and one of them part-timers. She probably works all the time. But I'm going like, where are we at? Because I'm going to call Charles and say, Charles, how'd you write a letter to something you didn't even know was there? And I know that it's all, at some point, as you say, checked off on. But, Tennessee Valley brought in, I don't know how much they wound up, 30,000 curies or something that they didn't need. Well, we lost it. You did, the state did, Andrews County did. And I didn't really want to prove it, but I just like to have something. It is, Mr. Chairman, a very delicate balance that you do get these guys, and the aggregators have their clientele that they go around to these small hospitals like Herman General probably, and they may have one cup of something, and
big cup size.
We got a little bit of money to get rid of that this year. We want to get rid of it, but I still think a lot of people are holding this stuff in their basement, even though they have a way to get rid of it.
Yeah, no, we don't want it there.
No, we don't want it.
Mr. Chairman, if you deem it
timely, I'm prepared to make a motion and that could be discussed.
We've discussed this one for a lot longer than I thought we would, and it is timely for a motion. All right. Mr. Head of the committee that evaluates all these things.
I make a motion that we approve an import agreement for Philotechnics 1-0033-00 for sealed sources, Class B and Class C unstable, from the state of California only, material from Stanford only, for 100 cubic feet and 15 curies for a period from April 27, 2013 through August 31, 2014.
Okay.
Second.
We have a motion and a second. Do we have discussion? Or have we discussed it? Anybody want to comment about the motion for edification? All right. You've heard the motion. I'll call for a vote. All those in favor of the motion say aye.
Aye.
Any opposed? The motion passes. So, all right. That's 9B. 9C, RAM Services, application 0034-00. And John, I know you're calling it up.
Yes, the technical committee has reviewed an application for RAM Services Incorporated received by the Commission May 1, 2013, signed by the applicant April 25, 2013. RAM Services is a broker who is a licensed waste processor and collector, and they're requesting to dispose of materials, low-level radioactive materials in accordance with the Act. I would note that the applicant has provided generator disposal authorization for the waste and a certification that the waste is not of international origin. Their proposal is to dispose of sealed sources, stable Class C material, and they do have approval. The compact facility operator has approval from TCEQ dated May 7, 2013 to dispose of those materials. They are requesting 37.5 cubic feet and 81 curies of total radioactivity. I believe for this application it has the same fate as Bionomics in that they are awaiting the central compact update.
I think you're right, but they do have authorization today, but the authorization expires June 30th, 2013. I think it's June, maybe July, June 30th, 2013. So it would be renewed. So they do have the authorization today. If they were to ship today, they have it, but it expires either June 30th or July 31st, 2013. But it appears it'll be renewed potentially at this meeting. But if it wasn't renewed and they shipped after the expiration, they wouldn't have it.
Right. But they have provided generator authorizations for all of the material. So it doesn't appear that this material, that they are speculating. They have the material and are ready to dispose of it.
Okay.
I would also add that RAM Services has requested that this material be disposed of under a small quantity generator set aside, and based on the curies and volume, I would agree. I believe the RAM Services does not have access to another disposal site for the materials, and they have requested an authorization through April 26, 2014. I would suggest that we consider changing that to August 31, 2014.
Is that it?
That's it. And the technical committee recommends approval.
Okay. Any questions? The tech committee, Mr. Salzman.
There's no question that they've applied for the extension, I take it.
my understanding in discussions with Jerry, Jerry we've asked that they have. And there's a copy of what they have currently in your notebook under tab 16.
Yeah.
And he says they have.
Any further discussion? Questions? John, motion.
I make a motion that we approve the import application from Ram Services Incorporated. That's 1-0034-00. Material coming from the state of Louisiana, sealed sources, Class C, stable, a volume of 37.5 cubic feet, 81 curies, for a period that would, with a import agreement that would expire on August 31, 2014.
The motion, is there a second?
Second.
Motion been made and seconded. Any further discussion among the commissioners?
What are they asking for of the other commission? I mean, are they asking to extend it for a year?
I wish they were here to answer that for you directly. My understanding is that they are, because that's the standard operating procedure of the Central Compact to do them yearly, and that's what they're asking to do. But I couldn't say that for sure. I mean, we could put a condition in the motion that says if they ship after July 30th, 2013, they need to provide the updated export authorization form to ensure.
That makes sense.
It does, yeah.
That's okay.
I would agree with that friendly amendment.
Second.
Is that okay with our second?
It is.
All right.
And since this goes into 2014, Karen has reminded me they would need a second renewal potentially if they ship that far in the future.
Either that or we set it to expire when their expiration expires on June 30th of 2014 if they get the renewal. All of those are possible.
I have no opinion.
I'm trying to conform to the motion.
Yeah. Well, we have the motion through August 31st of 2014. Doesn't say anything about the conditional renewal after June 30th of 2014.
But it does have the condition.
But it does have the condition that they need to provide the authority, so impliedly the authority would be there only through June 30th, 2014. So if it expired, then the agreement would technically expire, I would think is the way that would work.
We can write a double condition.
Yes. All right. So y'all have heard this particular very complex motion. Is there any further discussion on it? All in favor of the motion say aye.
Aye.
Any opposed? No opposed. Motion passes. And before I think we keep going, because I think we're going to exceed our tolerance limit, we're going to break for about 20 or 30 minutes to allow people to get up and stretch, because we did 30 minutes the last time, in spite of the fact that I said 15. We'll go down and we're going to take a break of about 45 minutes. Well, actually, I intend to be back here at 1:30 to resume and carry through the rest of the morning.
All right.
Yes.
Lunch?
Yes.
Official lunch break?
Unofficial lunch break.
I figured out a college thing for the attorneys that, you know, y'all could have a college.
I probably can't answer it.
All these guys that doesn't show up. And y'all always
Let me turn this off.
But you probably couldn't do it legally. I'm just trying to, you know, this state's open for business, so I'm just trying to. I'm in Austin, I gotta do what the governor wants. Yeah.
I might go down there and wander down there.
Yeah, I know. I think that's possible.
We need to
Yes, and unless they know what they want, they don't have anything to
That's right.
And I understand that.
Friends of theirs, technical experts,
Stuff until we
It's not. It's hard. It's not part of the law that says that
and I realized it really become a He decided on it. Went out and sort of set an arrow.
So I'm not worried about it.
But I'd rather go back.
Big deal. Plants started blowing up within a day or so.
But don't worry about it.
Big, so even he can't do it. So now he's in all these proceedings and he's apparently a national figure in Japan because fair wind.
That wouldn't be interesting.
I think we have plenty of intellectual stimulation to go.
Anyway, and they have translated it into Japanese. He's got a book out in Japanese.
And the things are shaking the can. But I see the argument. So, see, how can we?
I don't know. I think
We're charging portal to portal.
I don't know. I mean, it is still friends of the earth, so I don't know how much he was charging. He was charging the rates of a high school math teacher to position 5 years ago, and then he got up with funny because they wanted counterweights to Army, they had to make real nuclear engineers, so they had to pay nuclear engineer consultants, right? So they wanted to editor that for any Sure. Thanks. No wonder the motion sensitive.
I mean, this has got to be, not business aggregating these ways. It's got to be a nice business, I mean, because there's a few people who are willing to kind of go and learn the rules and do it.
Looking forward to Sorry. Okay. The actual Word document.
Yes.
I have a lot of input on it. And what you're talking about earlier over here, assembly associates, how they well, I think that's what, I know right now that I think that's kind of the nature about discussion. Creating a hardship in the circle. Right, and on the other hand, they dig probably comments. Someone's concerned about, I don't know how we're going to do this, but yeah, there you go. What the brokers do is, there's a lot of my stuff, California, goes back, Ohio. Ohio, California, for time 5 goes back to Ohio, so there's more in demand now. A lot of them recently come to us, and the brokers are now getting rid of it for free. We charge them money, we'll sell them the game rates and get advantage from us. But then additionally, I think what brokers do is that they know they're not going to influx sources that they're going to receive, and then they go, oh, Jerry, was it for services? Well, when he did so all the brokers, I mean, I can't tell you how incestuous it is, where I think that, you guys are seeing this broker considering value, but what I'm seeing over here is that I see material for one broker, bam. They shuffle it all over the country.
But really the
It depends on the nature. Oh, it is complicated, very complicated. Yeah, are you guys here this afternoon, or are you? No, I think we're going to call it, the majority think that we need, we've addressed, I will definitely give you feedback on that. I'll make sure that we get to put on the website. Thank you, John.
They should be able to change this information or else they don't want to do it. We need to know what they want to have. Because they can file the paper, yeah.
That's why we need it.
Why we need it?
Well, as a compact.
I agree with.
Not as a voice spoke.
As a compact commission?
Yes, why as a compact commission?
Oh, my God. So that's why
My problem with that is due diligence on CCQ, making sure that they do what they're supposed to do. And everything.
Well, so just give me a whiz. Because, I see the compact commission being more limited than I originally envisioned.
What the question I had or not, what do they do?
They just want to make sure that they have records for all the Latin official users, maybe like
well, you want to know what
California.
For my compact is California, Arizona.
We need to know what we
They have to prove that it went from final disposal.
Okay, that's okay. Okay.
All right, thank you. Appreciate it. Do you have a card? Because I like to market this and stuff. You got it.
I think probably my last card is going, I filled up car.
Well, I don't know where.
They have good salaries.
I was going to say, it sounds.
They really do.
I'm taking a phone call, really. We reuse.
Well, and sometimes you do, and that's okay, because then the people that got it from that,
Yeah.
I don't care about those.
Well, I have a question for you. So what's going to happen when we ship the source out of California under a billway, we hold it for a year, and then all of a sudden we say, okay, we exhausted our reuse or repurpose of the source, and then eventually it's going to say, okay, we're going to we don't need to go back and get an import permit from you at that point in time.
Did you really do a reuse of it?
No.
Sure, I'll give you a card.
Well, I talk to Rich Gallego a lot, which
okay, that's on the train,
yeah,
right.
so I'm sure that.
I'm just trying to look for some other cards
right.
too, so.
Okay, so we're manufacturing. Let me even back up. We're manufacturing. We've been manufacturing 56 years in Texas, but we've acquired a lot of customers. Okay, we're Fortune 500. So.
No, that's okay.
Okay.
Marvin, I got you.
Okay, so.
Marvin Smith. Okay, and I'm Kathy Davis.
Okay, so we're a manufacturer distributor. We're the largest manufacturer, and what we do is we take the wood capsules that look like sewing doubles, I'm sure you've seen them, and then we encase them in steel, lead, and then we sell electronics. We're the largest supplier of like petrochem, refineries, coal power plants, all that type of stuff. When we bring the source back in, we have, first of all, we've implemented new SSDRs, Steel Source Device Registries, for our manufactured product. We're putting 2 old sources in there to get the strength of one that we would
504.
Okay.
So that makes business sense for us because we're collecting
Right.
$2 and
So you're able to send that out for a reuse.
Correct.
I don't need to hear about that.
But what happens if once we get it back in there, we extract the source out, let's say we scratch it a little bit, let's say we look at, once we get the source out, we look at it and go, you know what, this is just too risky for us to use.
Right. But that was our intent when we got it from the customer, and then a year later, 2 years later, after it sits in our facility, we deem it, you know what, this is something that we have to get.
Yeah, we're going to have to get rid of it now. And so John's paper, we have a white paper he distributed, and a lot of this, I mean, you can see manufacturer. I mean, basically, they could have struck manufacturer with Thermo Fisher in there because that's what we were pressing these questions. Is that, so when we deem the material waste, okay, it talks about that if we manufacture the product, gold Texas Nuclear used to be about a mile down the street up over here. If Texas Nuclear manufactured that source, no matter where it went, South America, we can take it back and we can still call it Texas waste because nuclear licenses the state return the source to the manufacturer. Okay, so, but then also, as normal course of business, and we've been doing this for 56 years, we take back our competitor sources, Berthold, Ronan, Omar, and a few others. But now, mind you, we've also manufactured over 100 different products, nuclear instruments. So we take back similar and like products to the industrial applications that we do, analyze and use the sources. So we collect a lot of material back.
Not necessarily what you manufacture.
Yes, because it's normal part of doing business. Okay. So, but now what we get to is our intent is, number one, our intent is not to pay WCS a single penny. We would love to create a new business, find a use for this, put it in all our new product, give it off to our sister units. We're looking at recyclers right now in Germany that can potentially take our material. We're looking at minimizing our costs. But now going back is that if we extract the source out and it's scratched and it comes from California, and also we say, you know what, we can't use this. Okay, we ship it under bill of lading. It's a straight radioactive material, shipment. It's not waste. And eventually we are going to deem it waste in Texas. Okay, now according to John's paper over here, the waste generator would be not us anymore.
It would be the last beneficial user.
Last beneficial user.
Right.
But
wherever that may come from.
But now we have sources at our facility that are 20 years, that we've had for 20 years. We don't have to go back to California to get an export permit, do it.
Now, over 20 years? Well, I would say we've been in business, federal law since '85. So
we're not waste broker, we're distributor. And I think.
But we can get into all those technicalities, but from my commissioner.
Yeah, from your standpoint.
From our standpoint is that this company had this source and they used it. And they had to have it out of the state radioactive materials license to even get it. And they have audits on the state and they have to track and submit their paperwork to the state. And so say the state doesn't come out and audit once every 5 years or so, or when they renew their license in time to pass.
You mean you're California user?
Yeah,
right.
But they want to know where,
that source wants it.
Where did it go? And they'll say, oh, well, we shipped it, but it was no longer, any good.
Even before that, what we would do is we have to establish reciprocity with California. We would contact California, tell them we're going in there to retrieving that source, taking it back to our facility. 30 days after we get it, we issue a transfer letter to the end user for his documentation. But then we also, on a quarterly basis, we go back to California and we tell them the sources, or actually, California would report it because the end user, what I tell the end users to do in California is to do your annual inventory and submit transfer paperwork that you transfer that material to us under certain material license transfer, and then we add that source to our inventory in Texas.
But it's gotten a little more complicated since, and I understand that process, but since we use Qualtech as an example, they had transfer papers. And the problem was that they even in some of their papers, they acknowledged right away that, hey, this is just going to be for disposal, but we have nowhere to send it, so we'll just hold it for you. Get it out of here, because they're limited to how many they can have on site. So they want to get that one that they're not using off the site, so they can get something else in, because the state regulates how much they're going to have.
So they ship it off, but there's still the last beneficial user, and the concept is the federal government has come in now with Homeland Security and said, sealed sources are the perfect type of concept for getting on.
Sure.
And we want you to tighten down how we're tracking you and what we're doing, and we want proof of disposal. And so they've gotten a little more technical. So from my legal group, you know, they're looking at that, and they looked at the paper at Qualtech, they said, no, they need a petition. Right.
But Qualtech's also a waste broker, and Qualtech, any intent Qualtech has to take a sealed source would be to
But see, but initially when we said, okay, we want petitions, they said, well, we're really not a waste broker, we're just a.
Well, we're a manufacturer. We're a manufacturer first and foremost. Yeah.
Well, I mean, we got several different titles of who they were.
Yeah.
You know, so it was, well, but if you're out of this state and you're handling that, you should be going to Northwest. Well, they couldn't go to Northwest because Northwest is state. That's not for you. You didn't collect that.
Exactly. Yeah.
So I mean, and so they're just trying to kind of probably find a common and be consistent with how they treat everybody.
Not wash their hands so easily after you transfer it once.
Right. Out of it, and then, yeah, you don't have to worry about your responsibility. Right. That's the last beneficial user.
So the last beneficial user, I know where it was finally heard.
And where did it end up? In the last case with RAM Services, where they had picked up, I called some people in North Dakota at a veterans hospital. And, hey, Monica, this is so-and-so. Really? Who are you? Well, you know, I oversee disposal, and, you know, when you do this. Really? Oh, I didn't know that. I said, well, I've got this stuff you shipped to so-and-so. Oh, years ago.
And you ship up to RAM Services.
Yeah, they went to
RAM
RAM
Services to disposal.
And so I said, yeah, but they're just now disposing of it. She says, you're kidding. I didn't know that. So it's like, she could have sent it off to someone. She didn't know who she went next to, buried it in their restaurant. She would have not known. And she didn't have any proof, no documents of where things went. And so then when the state, you know, the state rep that comes to my meeting, I say, what are you guys doing over there? Yeah, that's a good idea. We should go. So, and it's only because I think a lot of it is Homeland Security.
For various other reasons that they should know. And there's ways, I mean, to track all the sealed sources, but I mean, what I'm kind of going back is that if when we deem something that we can't reuse it, are we going to have to come back to you guys and tell you, and then go back to every one of our thousands and thousands of, I mean, literally we probably have 10,000 end users out there, and try to get.
Just my compact, and I think there's one or two other compacts that require some type of documentation. Not all the compacts track it the same.
Yeah. Okay.
But if our initial intent was to reuse it,
we prove that.
Can we be deemed the last beneficial user?
I would tell you I'd get a legal opinion, but right now the way it was from the past, no.
Well, I think, and for their intent and purpose, what John Salzman was telling me, is their intent and purpose, especially when it comes to us, he goes, if you guys are willing, he asked me, he told me, because if you guys are willing to pay out of compact pricing, we don't have an issue, we want to promise. I said, no, we don't have a problem with that, because it's not fair for us to, I mean, we don't want to be in a position to undercut
right.
the state out of compact pricing and take in all the material, make money, and okay.
And they are afraid of that.
Yeah. And I grew up in Texas, and I don't want Texas to get ripped off. I don't want someone else doing that, and I don't think we should do it.
If you have gotten it from outside your state.
Yeah. However, but more or less what I'm thinking is, even though if the intent, and that's why I want to give you a clarify, and give John Sullivan's comments back, is from our standpoint, and we can prove intent to reuse upside down. We have programs, we do more programs. We're doing everything to reuse these sources as a manufacturer. 56 years of manufacturing. So, you know, I'm hoping that even though the last beneficial user would be derived in California for the intent and purpose to make sure that the state of Texas gets there out of compact pricing, that doesn't necessarily mean that the last beneficial user, we need to supply documentation that from the California generator getting approval to dispose of the sources, that we should just be able to just go straight in. without
And I
extra
guess I
import
will say
permits.
to you from the same perspective that, hey, I don't want to screw Texas. Hey, you're screwing my compact.
How?
Because I get an application fee, and that's how I fund my operations. And that's
really?
how I track, so that I'm working with the state, in connection with the state, so that we can cross-check to make sure we know where the system is gone. So if I don't get, so Qualtech
Really?
ended up, owing me $3,000-4,000, so it seems like a little bit of amount of money to do that. But it was still, if I'm a one-man show here. This is the office, just like Lee is the office. I don't even have an office work out of my home, just so we can keep the costs down. Because originally, we were opening Ward Valley. I don't know if you go back, it used to be that long ago, but when we did Ward Valley, we followed the rules. Okay, out by Needles in California, that was gonna be our low-level facility. And we went to, had the U.S. Ecology was gonna be our contract on it. They did all the environmental impact, we sent a few hours of the Indians, people playing accordion, all that kind of stuff. And we licensed the site, so the commission was ready to operate, much like Texas. And then because it was on BLM land, even though this was federal government directing us to go do this, another department of the federal government, the Department of Interior, at the last minute said, we're not gonna transfer the land to you because it's an Indian burial ground. So it's sacred.
Sound like you're a Republican in California.
Yeah, I am. I was sitting on the commission at the time when they did this. I was a county supervisor. And that Ward Valley was in my district, so.
Okay, also with the.
So we lost all that, so then we lost the potential, so how do we fund this and how do we prove down the future? Because the California state is still mandated in our compact agreement as the host state for our low-level waste. So if we can't track our waste and know how much we're generating that, we can't possibly go back to the legislators to justify that we need a site that, eventually this site, 30 years, 40 years, will get full. And so, again, we'll be backed up with our back against the wall saying, okay, legislators, Democrats, who say, oh, we don't want any of that stuff, we don't want to do that. And we're saying by federal law, you signed an agreement that you would take this. By federal law, you signed, with these other 3 states, you agreed to do this, and now we have no other place to go. So 15 years out from when this site closes, we should start working on our site. Again, disregard, and technically, Ward Valley was the best place in the whole state. But will we be, the hope is maybe all those guys, including, be dead by then. And so 15 years from now, we'll be in a better position and get it through.
And then through the application process, you've got proof of how many.
Exactly, and does it cancel out for value, and how does it compare what else we'll be able to collect from others?
Right, yeah, and fees or,
Right, and Energy Solutions, shoot, they got a 30 to 40 year timeline, and then where are they gonna go? And at any time, the state of Utah, the people can say, we don't want anyone else to do it.
So like Harlem,
Exactly. So it's like, okay, Energy Solutions, come on over here, let's be working. And so the state officials know that that's down the road. And so they want documents to show proof, even though we've recycled our governor now, because it was Governor Brown who at first refused to, be cooperative and develop the site. And so now we have Governor Brown back again, 30 years later. And of course, we still have the same attitude about it. Because I was in during the process of Pete Wilson. So that's kind of where we were, high gear, got it all done, ready to go, have the site, get income, or, just an economy out at meals.
Who do you answer to? Just out of curiosity.
That's a good question. I don't know. Just answer to ourselves, right?
No. What I'm saying is does.
To all 4 governors of the compact, I guess, technically, you could say.
How do you work with the licensing groups within the states? Are you tied into the like the dishes or whatever over here? Texas Department of.
I don't work with them.
Well, I know you don't work with them, but
I have a public health. Okay, I have the radiological branch in the state of California.
Who issues nuclear licenses for end users?
Right,
Okay.
right. Are we supposed to
Yeah,
move around?
okay. So did you work closely with them or not?
With who?
With the licensing group, the radiological, you work closely with them? Because, you know, in my opinion, for what it's worth, is that sources that we did, are you walking out?
Yeah, I don't want to say sorry.
Yeah, sources that
need the caffeine.
Yeah. I got iced tea, so I'm with you. Hello? Oh, not much. I was just gonna suggest if you get over there at 2:30, one of the things you might do is run by Sam's before you go and take a few minutes, because they have an optical shop in there now. That's where I got my glasses. You can just go over there and kind of look at frames and some stuff like that anyway. If you have time, I mean, you don't have to, but it just might help your decision making later on if you have a chance to look at their prices. All right, well, good luck with it. Actually, I think Sam's is lower. Yeah. So you might want to run by there and take a look and do real. Yeah. Yeah, you don't have to show anything. They show when you buy anything. But you can get in and look for glasses, what all you might be on the right thing. Anyway, you might do that. And also, when you finish, they're going to give you should take your sunglasses with you. Take them inside because it'll be really bad, and you need to be really careful driving home. Okay, all right, well, I'll give you a holler. One of the things you're going to have to plan is it's going to be a couple of hours before you're going to be able to drive to Houston, at least, probably. So you probably won't be able to drive to Houston until about 6:30 or 7 o'clock, maybe a little later than that. It takes a while for that medicine to wear off. Anyway, all right, well, I'll give you a holler. I'll give you a holler when I get out of here and start heading back to College Station. Oh, yeah, no problem. Just got there late, but no problem. All right. Yeah, like I told Karen, I'm sorry, I won't be going back there. That's ridiculous. So anyway, but that's okay. All right, I'll give you a holler when I get out of town. All right, love you.
It is from back here.
Yes, I know. I'm going to have to do something defensively about that.
Don't think there's any hurry.
Hello.
But the chairman is back, though. That's good news.
No, it's not.
Oh, yes, it is. Yes, it is. I don't know what we do without you.
Yeah, I've got a lot more progress.
Well,
Did you get any water when I got that out?
No,
I didn't, but that's probably a thing for a number of reasons. And since I'm not talking, I really don't need it like this. Okay, well, thank you. It's still so wet. They usually get somebody from the Capitol there.
Test.
Sure of that. Yeah, what do you want me
You know, when Mark was up here, I could actually hear him.
At the last minute, so
This one was working.
kind of fell.
Test, 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 test.
Yeah, that's what I thought.
I noticed that when Kathy was talking.
Now, the other one,
Test.
This one?
It's not real loud.
I'm not sure yet.
Test, test.
Yeah.
It's working.
Test, test, test.
It is working. Close enough to them. I wonder why. Normally they're very. They're just not turned up high enough, so where's that? Normally they're very sensitive.
yeah, they are.
Like all those commissioners.
That was quite the white paper, sir.
People ultimately not agree with the way you're here. Back in the day when I was more operational, you work all day, fly all night. Here's how they're going to be applied. We're going to be applied to you.
Exactly, yeah. What day is it? Where am I?
They're not playing favorite. Well, I mean, the more I delve into this,
No, it's
Test, test.
This is really.
Volume's right here.
Thank you, Dan.
Guess how I work highway through school.
AV right here.
Well, you know, we need an AD.
Test. Test, test.
Yeah, thank you.
My work here is done.
Hey, Don.
Hey, derelict. You call me derelict? Derelict, is that pretty close?
Yeah, I had a friend of mine, kid,
derelict. There you go. You've got the mind of a 6-year-old, right? There you go. I was stuck in that. Good time.
I just want to give you. No, I understand. I don't be able to live.
Just share it. You have progress. Yes, that's clearly.
Well,
I think this is a good effort.
You know what, they completely, that list is still running long.
Can I get you to send me a copy of that?
I know. As a matter of fact, if you give me, hand me that notebook right there.
So you're going to
I'll give you one.
I'll only make one copy. Let's go back and forth on that all the time.
Whenever we make 30, people take 5. And so we decided, okay, we kept going away. So we said, all right, we're going to start making sure and then, of course, today, so there's your copy. Thank you. You're welcome. And we'll get on the webpage tomorrow.
Well, you need to do this, you're going to have all.
I've got it. A bazillion different ways electronically that I can pull up or my
Thank you.
You're welcome.
Yes.
That's right.
And I'm the only one. So I let me know.
Well, and they will then, they're decommissioned. We won't do it tomorrow. It'll be next week.
Nobody can interview anything about this like
They can't keep it forever. No, make sure you're there. Just answer my question. That's helpful.
I think you two are doing a fabulous job on that. Outstanding teamwork. I mean, the teamwork I'm seeing is absolutely.
Well, the judge would be happy about that.
Okay. Yeah, I missed something, so I know you caught it. What? Wait, and you're part of it. So do we decide your paper, the white paper, is going to be part of the new one? Yeah. And we didn't take any action on it. That's what
And as a part of that, is it allowed that she go ahead and put the paper onto the website so that people could actually access it electronically?
We're going to bring up copies. Yeah, we're going to put all those up. And then, what I'll do is I'll bring it to
What we can do is when we start, just put a little notice on it as a result of our meeting, we're inviting people to comment, and we would say the white people that was discussing being on the website. So we're going to use it and the existing rules that are starting in place for determining what changes we want to make.
Yeah, we've got a rules page on our website, and that's where all this is going to go, because now we're doing. Yeah, it'll be on the, because one of the things that were part of this meeting.
It doesn't reflect real well.
He's got the most awesome ringtones of anyone I've ever heard. I don't know who does it more.
I have the standard AT&T ring, and I never change it. I could, but I never change it.
I thought about maybe doing some less that.
There you go.
Yeah, I haven't done it.
Actually, I would probably like to do it like the Doobie Brothers.
Yeah.
You'd be doing me a favor, take it away.
Smoke on the water.
Yeah.
So there's plenty of. I'll take some of yours.
Oh, there's tons of candy here.
I don't want to take yours.
If I ate all this candy, I'd be in huge trouble. I don't want any of the chocolate. I love it, but this one.
So what are you doing this summer?
Actually, I'm changing director of environmental safety for A&M. Becoming director of environmental health and safety at UT. So,
Put him in the closet.
I'm being very. It is. Very much.
Well, yeah.
This is awesome. They take the good portion to sit up here. Bring the Goliath.
Manchester is about
And then you get behind them.
2.5 hours. Boston is, well, Logan Airport, which is a little longer than is about 3
Yeah.
But Manchester is a much easier. Yeah, in Boston.
They had the
Traffic getting in and out of the tunnel, so
Manchester.
turn to go this way.
No, okay.
I think about Washington.
You're not like
New Hampshire. It's really pretty. So where do you going there? And that would be another part.
They went from
That means you'll let them walk and cut along without a signature. You won't be
prettiest road to take across.
And that's okay, you know, usually political cover like
Because
that.
kind of work out
You can say, well, legislature.
I'd have to take a look at the map, you know, to work out an easy route to get on that.
But we do have to figure out the money thing.
Across the, I mean, well,
Huh?
I have a problem the way they're set up.
Yeah, I do too. I've talked to Betsy about that, and I'll tell you about it. I don't know,
It's kind of like that.
I think we ought to put it,
Hampshire
use their paper.
is something like that.
Looking at traffic.
I know. But I'm thinking about it. I'm not thinking about it this year.
Here. Manchester is down, you go down here and then
you don't have to say anything about increasing your salary.
Yeah, I'll have to tell you on the later, it's in debacle in Caldwell County. I mean, it is a mess down there now. Caldwell, my county, judge down there, and an administrator, and the county commissioner voted to terminate that position. He's going around trying to get a district court in place to enter an injunction against the termination of that position. The accusation was,
very good.
basically the job was to oversee all of the department heads.
And they went about
That was the public
and they really made a good. When you raise your hands,
Travis County is around 38 people too, counting the others in 10, and they're all assistants. They don't call them administrators, they call them assistants.
Now, Washington had a kick 'em
Okay, folks, we're all assembled, and we're going to start the meeting again as soon as we quit talking to each other about other stuff.
That's what I'm doing this.
Didn't mean to interrupt, Deborah.
Taking care of me.
All right, we'll call the meeting back to order. Next item up for the discussion on the agenda today is item 9D, Sacramento Municipal Utility District. And Don, do you have this queued up yet, or 0035-00?
There it is. Okay.
Launch.
All right. Well, the technical committee has reviewed an application from Sacramento Municipal Utility District received May 1, 2013, signed by the applicant on April 30, 2013, and that's 1-0035-00.
Did you press the speaker button on there? And while I have the microphone, let me just do a big shout out for Dan Sherm over there, who figured out the problem was that we hadn't turned up the volume and got the microphone.
Here you go, Dan.
Dan the man.
Dan the man.
Do I need to repeat that, or are we okay? All right.
We're okay.
All right. SMUD is the generator of the waste. We have a letter from TCEQ dated May 7, 2013 that authorizes the compact facility operator to receive the material, which is Class B and Class C stable plant processed water filters, plant water treatment resins, and irradiated hardware. They have requested 3,136 cubic feet, 12,496 curies of total activity, an estimated 15,000 millicuries of carbon-14, and an estimated 20,000 microcuries of technetium-99. As discussed earlier, they are located in California, and to date we have not received an export authorization from the Southwestern Compact for the materials. With the requested activity of, repeat that, just under 12,500 curies, with the current limit of 120,000 curies, that's roughly 10% of the curie total that we can receive until August 31 of 2013. So I would probably have to characterize that as a significant percentage of the total curie limit that currently exists. For the annual curie limit, I should say.
Operational year curie limit.
Correct. I would note that the applicant has requested the volume in curies for a 2+ year period ending on June 30, 2015. So they requested a different 2+ year period. I'm not entirely certain how we should treat that, but those are I think most of the technical aspects. I do believe that the material is coming from the reactor that they are decommissioning, so at some point in time they will have to ship that material. It's not like they're an operating plant and they could continue to store it for the next 10 or 15 years. I suspect the decommissioning will take a few years, but not forever, not 10 or 15 years. And so at some point they will be required by the Nuclear Regulatory Commission to ship this waste in order to complete their decommissioning.
Okay. Anything else?
I think that's the technical aspects.
Lee, do you want to add anything? Okay. Are there questions of any of the commissioners? Dick?
Sorry, but
I know you do.
well, okay, so they haven't gotten that. I guess I have. My first question is this has to do with decommissioning. Is this a relatively small amount of the total waste they're going to have to ship out of that plant?
My guess is, it says plant process water filters, treatment resins, and irradiated hardware. My guess is these are the first two items, the filters and the resins, obviously were generated while the plant was in operation. So this is operational waste that they just have yet to dispose of. On the irradiated hardware, I would suspect that as they opened up the reactor, removed the fuel, there's also hardware, as in even in operating plants, that they've had to remove that they have to dispose of. So it's not unlike the kind of operational waste that we have received from other power plants. I don't believe that much of this is really directly related to the decommissioning. It's not the reactor vessel, it's not steam generators, it's not things like that. So you said they haven't gotten permission from their... From the Southwestern Compact, that's correct.
More questions?
Kathy, do you want to make a comment about they haven't gotten permission?
Have they even asked you yet, Kathy?
I have been in contact with them and asked them if they needed a export permit before the meeting.
And they said, what's that?
I have had that with them, but not from them. They indicated they weren't sure what timeline they were going to be shipping. And then now you're saying they're asking for a 2-year period. So, and see, our petition process goes from year to year. So maybe he's thinking, I don't want to file for a petition and pay you a fee and then not ship within that time period.
If I could ask, what would that fee be?
It's a flat rate fee for your facility for $225.
Excessive.
What year, I'm sorry to ask, what is your year time, when does your year begin and end?
Right. I start issuing the yearly petitions in November of the previous year. So it's November, December, and then all through January through December of the following year. And the reason why we have that 2-month period before is a lot of them do their budgeting, and they want to submit for their petition or submit their request before the end of the last fiscal year. So we try to accommodate that. So. But basically, January to December is the petition year. But if they want to, they can start shipping in November, December of that previous year.
So basically, your operational permission is on a calendar year basis, except that you will allow them to start shipping.
Right. So they have a 14-month period, technically, that they could ship if they wanted.
And when do you require your applications for that export period to be submitted to you?
As they need it.
Okay.
So if they come in on December 25th and say, oh, I'm going to ship, and I say, are you shipping before the last day of the year? And they say, yes, I'll issue them a petition. But it will only be good up till the last day of December. But I try to be pretty flexible, usually within 2 weeks, maybe a little less, pending on the mail and pending on my schedule when I'm in the office. I can issue a petition. I can do turnarounds if it comes in through email, or if there's an issue with someone else's meeting date, I'll work with that.
Okay. Thank you.
And the $225, I know that we used to charge $55, and so then I was the bad guy that came in and took over the job and made the recommendation for this massive increase. So, but it's within how we operate our budget. So it's worked well, and I'm trying to be fair to encourage B&C waste disposal. So we did not want to charge per curry on where we do on the A waste, but we didn't on B&C because we were wanting to encourage that disposal, and we didn't feel that we had an excessive amount that would...
$225 is per application.
Per application.
So they're getting charged to leave the state and charged to get in the state.
So, anything else?
Well, supposing we said, well, okay, they don't have permission from you to ship. Why should we give permission to receive and just say, let's wait until they have permission to ship? What kind of problems, if any, does that create?
Not really anything from my side excessive, only that since they're requesting a 2-year window, like was brought up by Dan Burns from WCS, is that they're doing a budget process over a longer period of time. And so they're probably wanting to work within that time frame. But if you wanted to do it on a conditional that they get the permit, then when they're ready to ship, they would have to come back to me, and I would submit it to Lee.
They don't want to pay. They want to be able to hedge. They don't want to pay
$225 right
to you.
Right.
We've already spent more than $225 worth of time on this application.
True.
And they don't want to
commit to me.
Commit to you, and they don't want to commit on a time less than 2 years. Thank you.
Okay.
Other than that, Mr. Stoddard, how do you feel?
More questions of the commissioners?
I think it's interesting they have it right down to the curie and right down to the cubic foot.
I had encouraged them to get it.
The only question...
Okay, that's the problem.
Only seems to be the time, and seeing as how they... we don't have a motion yet, but seeing as how they ask for a certain period of time, that doesn't seem to make any sense at all in relation to the because the way I see it is if they're on a calendar year basis for export authorizations, and they come in and say we want to export in the year that ends in 2015, they have to know that they're going to ship in the first 6 months of 2016, right? And so I don't see any reason not to give them what they ask for, if that's what they want as far as an end date. But I'm only sitting here thinking about it, running as we go. Is there a motion?
I make a motion that we table this application and give the applicant the opportunity to apply for an export permit from Southwestern Compact.
Is there a second? Second. We have a motion to second to table the application.
What would that mean? That we would take it up at the next meeting, probably?
Where they get their stuff?
The motion was to give them an opportunity to apply for an export petition, as I recall. The timing of that would probably mean that it would not come up at the next meeting unless they plan to ship by the end of this calendar year, from what I understand of the discussion.
Historically, for instance, we tabled the Qualtech application, and in that case, we just waited to bring it back up when there was something that had changed. So it didn't necessarily come up at the next meeting.
The chair decides to take it off the table. Parliamentary.
Thank you for that.
We have a motion and a second. More questions, more discussions.
Bring it back.
All right. If you ask for a vote, all those in favor of the motion to table, say aye. Aye. Any opposed? Motion passes. The table. Subject to call of the chair. All right.
Give me just 1 second.
Next one, and I'll make a rambling announcement so John will have time to find his computer. 9, looks like E, Thomas Gray and Associates, application number 1-0036-00.
The technical committee received an application from Thomas Gray and Associates / Environmental Management and Controls, received by the Commission May 1, 2013, signed by the applicant April 16, 2013, and that's 1-0036-00. Thomas Gray is a broker who is also a licensed waste processor and collector. They have provided authorizations from the generator to handle the material for disposal. They're proposing to import authorization for Class C stable sealed sources, which was approved for disposal by the compact facility operator by TCEQ in a letter dated May 7, 2013. They are requesting authorization for 7.5 cubic feet, which is essentially 1 drum, 6.103 curies, and 20,617 nanocuries of I-129. The material is coming from the state of California, and the applicant has provided export authorization from the Southwest Compact for the materials, Southwestern Compact. Thomas Gray is requesting that the material be disposed of under a small quantity generator set aside, and based on the volume and curies, I would agree. I'm not aware that the applicant has access to another waste disposal facility for the materials, and they have requested authorization to end April 30, 2014, so an even different year than we have had previously. I think the Commission should consider extending that to August 31, 2014. I think that's all the technical aspects of the application, and I would recommend approval.
Okay. Questions? Kathy, one question for you. Does their export authority end December 31st of this year?
I believe so. I'd have to bring up the applications. They had several parties, didn't they, in the application? Was that what UC Berkeley?
No, this is Eckert and Ziegler. I can put it Burbank, California. I've got it right here, Joel.
Yeah, okay. Well, if it, at the bottom is the number 13?
Yep.
So it would end at the end of this December, the petition. So that they would, however, if it's been picked up from the facility prior to December 31st, then that petition is valid.
In other words, if Thomas Gray and Associates is actually in possession of the materials at their facility,
yes,
then even if they ship it after December 31, it would still be...
It would still be a valid petition because it was picked up from the facility and left at generator's facility.
Okay.
Because the understanding is the number of petitions, they be picked up and then they're not processed right away, or they're held. Thomas Gray and EMC have a 2-year limit that they can hold things at their facility. So there's that flexibility of if it was picked up, it could be 2 years before it was actually sent for disposal.
How do you enforce that?
Working very closely with them. And then every year they send a disposal report, and either they've disposed of it or they indicate it's an interim and it's in holding, And then that's attached to the petition. And then, so then there's a yearly review.
Okay. Any further discussion? Motion.
I make a motion that we approve the import application from Thomas Grain Associates, waste coming from the state of California, waste description is sealed sources, Class C, stable, for a period ending August 31, 2014, for 7.5 cubic feet, 6.103 curies, and 20,617 nanocuries of I-129.
Okay, is there a second?
Second.
Motion been made and seconded. Is there any more discussion among the commissioners? If not, all in favor of the motion, say aye.
Aye.
Any opposed? Hearing no opposed, the motion carries. And next is Xcel Energy Prairie Island Nuclear Plant. Number 1-0037-00.
The technical committee has reviewed an application from Xcel Energy Prairie Island Nuclear Power Plant. That application was received by the Commission May 1, 2013 and signed by the applicant April 26, 2013. In this case, Xcel Energy is the generator of the material from a nuclear power facility. We have a letter from TCEQ dated May 7, 2013, which authorizes the compact facility operator to dispose of the materials from Xcel Energy, Class A, Class B, and Class C, stable and unstable bead resin and cartridge filters. They're proposing a volume of 500 cubic feet, total radioactivity of 500 curies, 1,794 millicuries of C14, 5,950 microcuries of technetium-99. The waste will be coming from the state of Minnesota, which is part of the Midwest Compact and does not require export authorization. And the technical committee is not aware that the applicant has access to another disposal facility, and the applicant has requested an import authorization through April 26, 2014.
Okay.
I think that's it, and the technical committee would recommend approval.
All right. Any questions of the technical committee, commissioners?
Was that August 31st, 2014 date?
Yes, when I make a motion, that'll be. I haven't done that yet. I want you all to have a chance to discuss it.
Any questions or discussion? Okay, I'm ready for a motion.
I make a motion that we approve the application for an import permit from Xcel Energy Prairie Island Nuclear Power Plant, number 1-0037-00, waste originating from Minnesota, waste description of bead resin and cartridge filters, Class A, Class B, and Class C materials that are both stable and unstable, with a volume of 500 cubic feet, 500 total curies, 1,794 millicuries of C14, and 5,950 microcuries of technetium-99, with an end date for that agreement of August 31, 2014.
So moved.
I guess there's a second. Is it? John made the motion, you seconded it?
Oh, yeah.
All right. Motion is a second. Is there any further discussion among the commissioners? Okay, so all in favor of the application, say aye.
Aye.
Any opposed? It passes. Okay, that completes item 9 on our agenda. Next is...
Actually, I believe there's one more.
Oh, I'm sorry, Zion. I was leaping ahead. Zion is, I'm sorry, it's 1-0038-00.
This is on the next page of our agenda.
Yes.
The technical committee received an application and reviewed it from Zion Solutions. The application was received by the Commission May 1, 2013, and signed by the applicant April 30th, 2013. That's 1-0038-00. Zion Solutions is the generator of the waste. We have a letter from TCEQ dated May 7, 2013 that authorizes the compact facility operator to dispose of the materials, which is stable irradiated hardware, Class B and Class C. The application proposes 1,203 cubic feet, 16,000 curies, 3,080 millicuries of C14, 3,300 microcuries of technetium-99, and 1.58 times 10 to the 9th nanocuries of I-129, which is, in this case, listed as the lower limit of LLD, lower limit of detection. The material would be coming from the state of Illinois, which is part of the Central Midwest Compact, which does not require export authorization. I'm not aware that the applicant has access to another disposal facility for the materials, and the applicant has requested import authorization from the application approximately 2 years.
Two years from the date of the application, 2 years from now, what?
It literally has the approximate sign in 2 years.
What's that?
Their import agreement period they've requested.
Yeah, I see. And what the little squiggly line was.
Approximate.
Oh, approximate.
More or less. Lots of minutes. So, do you have a recommendation?
I recommend approval of the application with discussion of the length of period of approval.
Okay. Are there any questions or discussion of commissioners? Peter?
John, do you have any sense that they're decommissioning 1,000 megawatt reactors there? Is there a lot more to come?
We've approved. I'm not sure I have that. In fact, let me see. I think I might have that with me. For the first operational year, I don't have the actual disposed amount in front of me, but we approved import permits for 2,500 cubic feet and 13,000 curies. That also was irradiated hardware. So from what it appears, they're cleaning up the cores of one or both reactors, the various hardware associated with those. I really, perhaps others could, but I can't really speak to the issue of pressure vessels and things like that, which obviously eventually have to go somewhere.
Any more questions from the commissioners? We'll get to you in a minute, Dan. Let me just ask about a generic term. We use the term because I have a feeling this question is going to come. Irradiated hardware. What is included within the descriptive term irradiated hardware?
I'm going to ask if maybe Mark wouldn't mind if his lawyer would allow him to come up and answer that question.
Don't use the E word, you'll be all right.
Mark Carver with Entergy. Irradiated hardware can include metals that have been within the reactor core and surrounding components that are utilized, as well as instrumentation that's been irradiated within the neutron flux of a reactor. So it is primarily metals that have been exposed to a flux for any period of time, and then them themselves become radioactive.
My question is, what about turbine blades, things like that? Are they considered irradiated hardware?
No. Turbine blades for both types of reactors are not considered irradiated hardware.
At least you hope not.
No U.S. reactor has met the point. I don't know about the Japanese or any of the other national communities.
And so it's stuff that's exposed to the. I'm trying to figure out. I don't have a good design, and I'm not a technical person, as you know, in my head about where the irradiated hardware, how it would be exposed.
Mark, is it fair to say that that's generally irradiated metal or metal that is within inside the reactor pressure vessel?
Pretty much
in most cases.
For everybody, the fuel actually provides the neutron flux.
Yes.
And within that neutron flux, that is all contained within the core. It's got water in there, it's got the fuel, it's also got other metal structural components as well as nuclear instrumentation. And if that is in the field of the neutron flux, then it is considered irradiated hardware.
Okay. I just wondered
control rod blades,
what the scope of the term, how broad it was, or how narrow it was, and is there a presumption that it's in a certain area it's going to be irradiated, or do they actually test to see?
Pretty much it's based on proximity, location. Control rod blades, as Karen mentions, is a component that actually helps control the fuel movement up and down. So those control rod blades are made out of different types of metals, and they obviously become irradiated. So they are a major contributor. If you look at some of the petitions, they'll say directly control rod blades, velocity limiters, nuclear instrumentation.
Is it practice? And I'm trying to get to the practice of when you describe these things as a general, you just say irradiated hardware, or do you try to differentiate the different kinds of hardware that might be present?
They're normally generically I'd put the irradiated hardware in there. A reactor that's being decommissioned and torn apart. I don't have a lot of experience with that. We discussed Rancho Seco. I think they're at the end of their decommissioning, so they probably have all their stuff designated, and that's what this resin filters and irradiated hardware go to in whatever time period they decide to ship. Operating reactors have set components, and they understand and know what the metals are that are irradiated, so they call that irradiated hardware.
Okay. Thank you. I was trying to anticipate some questions or comments that might come up. So, and Dan, you wanted to talk to us?
No.
You've given up?
No, not giving up.
All right. Karen.
Hi, I'm Karen Haddon with Seed Coalition, and we would urge you to not approve this particular application. It would be very useful to have. I appreciate the information brought forward just now and you getting the answers to those questions, but I think that the applicants ought to be able to delineate a little bit more what they're talking about. We have had here previous applicants that specified control rod blades, and those were disposed of to the best of my knowledge. So I think that the applicants can and should be able to be more specific and that it's in the interest of the Compact Commission and others to get as much information as possible on the front end. And I did go ahead and write up a few brief comments that I'll provide to you.
Okay, thank you.
Thank you.
Is there any more discussion about the Zion application, including my dumb questions about things that clearly I don't understand about reactor design?
Is the allotment going to be in year 1 or year 2? You know,
We haven't
14.
don't have a motion yet, so the discussion, that's still part of the discussion. And Linda, if you want to bring it up.
I guess we need to know what year to put it in.
I think I would opt for the same end date as we have on the others, which would be August 31, 2014. So it would not be for a complete 2-year period. It would be more like 18 months.
And if they needed to come back and change that, they could.
They could request an amendment.
Right.
We can try. Yes.
My name is Dan Schrum. I'm with Energy Solutions, and I can speak on behalf of Zion Solutions. I sent an email to Mike Wiskirchen, just to make sure. I said, first, the Texas Compact will only allocate carries of volume for 1 year, so we should only ask for 1 year, so I don't know why he put the approximately 2. So we'd like to request this just for this year. And if we need to come back, we'll come back. But, and to answer it was somebody's earlier question, we're getting close to being done, but it takes longer than we are anticipating, and so hopefully not this year, it'll be probably by the end of next year that the B&C material will be out of the reactor.
So you wouldn't have a problem with put August 31st, 2014?
I would not.
One of my non-commissioned cohorts up here at the table is asking, do you know whether the reactor blades are included in the irradiated hardware? Control rod blades, I'm sorry.
They most likely are.
Okay.
It's just the internals. Whatever's inside the RPV, reactor pressure vessel, we're segmenting it right now, and it just comes out as metal.
Quite honestly, I feel like there has to be an industry standard that is in use with NRC and talking about this kind of thing, and that's what I'm trying to get to. Is there one?
Typically, it's just called irradiated hardware. It's metal that's irradiated.
I believe that is actually in NRC guidance. Irradiated hardware is actually a specified waste description.
It is.
And
so it's like resins, process filters. Those are.
I had thought that was probably true, and that was what I was really trying to get to see whether that existed out there somewhere. Because if it does exist, then that answers the question for the typical operator, and they're just following the practice that has been described, I would just call it that, by NRC. All right, thank you, Dan.
I have one question, just trying to, Dan, in C's letter to the commission, it says, it can only be assumed that the radiated hardware control rod blades, which are very hot items of radioactivity. My question to you is, it's not greater than Class C, A, B, or C, right?
No, we're characterizing the material as we remove it, and we would not be permitted to send anything greater than Class C.
Thanks to everybody for their contributions. John, do you have a motion?
I make a motion that we approve the application for import from Zion Solutions. That's 1-0038-00. Waste coming from Illinois. Waste description is irradiated hardware, both Class B and Class C, stable. 1,203 cubic feet, 16,000 curies, 3,000 3,080 millicuries of carbon-14, 3,300 microcuries of technetium-99, and 1.58 times 10 to the 9th nanocuries of I-129 for a period ending August 31, 2014.
Do I hear a second?
Second.
Motion's been made and seconded. Is there any further discussion among the commissioners? Any more questions? Anybody care to ask?
You said they do have whatever permits they need from
They are not required to have export authorization from the state of Illinois. I can go back and tell you. I can't remember which compact that is. Central Midwest does not require export authorization.
All right. We have a motion and a second. Is there more questions or discussions? Hearing none, I'll call for a vote. All those in favor of granting the application for Zion Solutions say aye.
Aye.
Any opposed? Passes. Thank you. Now, that concludes item 9. Next is item 10. Possible action, and on these, just so you'll know, I'm going to ask Linda, you'll take item C.
One part.
Yeah, yes. Consideration of possible action on the following petition proposed order for export. A is IHI Southwest Technologies, San Antonio. John.
I have to give you just a moment to get caught up.
What's the new law, September 1st on this? I've been voting against them for 5 years.
You just want to know whether you have to change your vote?
I had to talk to my senator about changing his bill.
Bionomics is I believe, in this case, assisting with IHI Southwest Technologies for an application to export materials for incineration rather than disposal. It's dry active waste, and the primary reason is the material does not conform to the acceptance criteria for the burial site. So in its present form, the material can't go to the WCS site for disposal. So they're proposing to incinerate it, but they still need authorization to do that. It indicates it's about 1,500 pounds of waste. And again, Bionomics is the acting as a broker for the materials.
Is there a recommendation?
Actually, one question I had was, does WCS have a comment about this petition, yay or nay?
Dan Burns with WCS, and we had previously sent a letter to the commission and we were supportive of these.
Okay, thank you.
Ready for a motion?
I make a motion that we approve the petition to export 1,500 pounds of GAW by IHI Southwest Technologies with the Bionomics acting as the broker.
Second? Did I hear a second?
Second with a question for Lean.
Okay.
Are we keeping up with what's going out? I mean, how much is going out of the state? Exporting?
We're getting, if I don't answer your question,
I'm just trying
behind me,
to think of what the legislature's going to want to report. Are we keeping up with what we're
do you mean the volume of curies that we export?
Yeah.
We have not been doing that. We will get reports back that confirm that the export has actually been exported and where it's gone, but we haven't done a running total. But to the extent that information is provided us or we can get it, we can certainly do that.
Well, I didn't know if the legislature's gonna want it in our annual report
Well,
or whatever report.
to that point, the legislature took out the requirement for an annual report in this bill. So we aren't required to submit. There is a requirement under the federal compact to do some annual reporting, but there isn't in the Texas statute any longer if this bill becomes law.
It was in the 2011 legislation, and there was already a requirement for an annual report from the Compact Commission that had somewhat different terms addressed to somewhat different audience.
Well, you remember when we first got on this as a report every week that was due?
Yes. I understand.
But to be sure, I and Audrey serve at your leisure. So if you commissioners want that totaled, we would be happy to get that for you, irrespective of Senate Bill 347.
It might be easier to write it on a yellow sheet of paper as we go instead of having to go back 3 years and get it when somebody wants it or something. That's just not telling you to do it, it's just a suggestion.
They take very good notes, and they're happy to receive suggestions.
I'll move my second, I guess.
Okay.
Call it.
Motion's been made and seconded to approve the export petition of IHI Southwest Technologies as described in the motion. All those in any further discussion, first of all? It's hadn't been described for an end date. I assume it's one shipment.
Well, historically, the end date's been the end of the calendar year, December 31st of the calendar year. That's just what you've been doing.
That's what we've been doing.
Mm-hmm.
That's why we want to continue that practice.
I think we could continue that practice, and that could be a issue that's taken up when that rule is reviewed.
Yes.
Okay. So that's part of your motion?
Yes.
Is it part of the second?
Second.
Yes. Okay. All right. We now have a motion and a second for an end date of 12/31/13. Any further discussion? All those in favor say aye.
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 Any opposed? Motion passes. Next, Southwest Research Institute, San Antonio, Texas, exportation of low-level radioactive waste.
We have received an application for export from Southwest Research Institute, which is in San Antonio. Bionomics will be acting as the broker for that material. It's 400 pounds of dry active waste, DAW. The reasoning for request of export is similar. The material is, in its current form, is not acceptable for disposal at the WCS facility. And I would note that, as indicated, WCS is in support of this petition for export.
End date?
12/31/2013.
Any questions about this particular application of the commissioners? I'm ready for a motion.
I make a motion that we approve the petition for export from Southwest Research Institute with an end date of 12/31/2013 for 400 pounds of dry active waste.
Is there a second?
Second.
A motion's been made and seconded. Any further discussion among any of the commissioners? Questions? If not, I'll call the question. All those in favor of the application being approved say aye.
Aye.
Any opposed? Motion passes. Well, the last one under this item is Texas A&M University. And John, do you want to introduce it and then let Linda take it from there? Or how do you want to handle it?
The commission received a petition from the Texas A&M University Nuclear Science Center for export of materials, but since this deals with Texas A&M University, I'm going to recuse myself from the rest of the discussion.
God, what are
Okay, Bionomics has submitted a petition to export low-level waste from Texas A&M Nuclear Science Center in College Station, approximately 2,000 pounds of dry active waste, a one-time shipment. It's for the same reasons that the other two petitions were approved. The waste is not in a satisfactory form to be able to be sent to WCS. So Bionomics wishes to incinerate the materials at Energy Solutions in Oak Ridge and then ship the waste to Energy Solutions in Clyde, Utah. So it is a recommendation of the Technical Review Committee that this petition be approved, with the approval extending to December 31st, 2014.
All right. Any questions?
I apologize for my earlier question. Withdraw it. Commend Governor Perry for giving us such a deep bench.
All right. Any questions of Ms. Morris on this particular application? If not, I take it you moved, and there's been a...
Yes, I did.
Did you move? And has there been a second? Okay. All right. A motion made and seconded to approve the application by Texas A&M University Nuclear Science Center. And all those in favor say aye. Aye. There are no oppositions, but show John abstaining from the vote, and so it'll be 5-1, 5 with 1 abstention, because I'll vote on this one to approve it. Okay. Next on the agenda, that completes the items under item 10 on the agenda. Next is 11. The reports. Dan, you've been up here several times. You want to come back and report to us on recent site operations, and then you can talk to us about utilization of full allocations of volume and curies.
Okay. Again, this is Dan Burns from WCS, and thank you for the opportunity to present to you. I just have a few remarks about current operations. Most notably, we're within days of reaching or exceeding 6 million man-hours without a lost time accident. So very, very proud of our team on that. With a small company like that, that's a huge achievement. So we continue to have great safety record. Operations continue to go smoothly, especially on the commercial side. We are seeing some more activity within our mixed waste treatment and processing facility as time goes by, which is helpful to us as well. And I did get a picture about 15 minutes ago, the first federal waste being placed into the disposal vault. So that resides where it needs to reside now. So we're real happy about that. And Rod does send his regards to you also, that he was out there emceeing that ceremony. So basically, that's the recent site operations. Things are going smoothly. We're operating safely, and we continue to pray. We continue to pray, and we also continue to prepare. The judge wants rain. Prepare for things that are coming up. And we're busy, actively working with folks try to bring in waste and things of that nature. With respect to the item B, update on the utilization, it's fairly simple and straightforward. At the end of April of this year, we had received about the 17,200 cubic feet of waste. It had about 167,000 curies of radioactivity as imported waste. So we came in well short of the 220. And since and of that part, there was about, I think, 1,940 cubic feet of in-compact waste, which contained 120 curies during that same period. And since then, and during the month of May, we've received about 1,000 feet and another 2,600 curies of imported waste. Came up short on the 220. I think we'd been bracing for and anticipating that for a while. And I appreciate everybody's efforts to get us as close as we got. There was a lot of things happened through the December period, and the commission was very helpful in making sure that we got as high as we got, and we really appreciate that. And it took all of us to do that. So I think it was good, actually. The last thing I would say is that on the in-compact side, we are working with all the in-compact generators and expect to see more shipments from the in-compact folks here this summer and this fall. So we're optimistic about that progress as well.
All right. Thank you,
That's it.
Questions, Judge?
Sorry. Can you give an update on the transportation?
Casks?
Casks.
Yes, sir. We are continuing to work through the licensing with our subcontractor to build 3 additional what we call Type B casks. And these are the specialized casks, of which there's only 5 of in commercial use right now in the country. So we do expect that those 3 casks, we will start receiving them at the end of the year and putting the fleet into service in January or so, right around January this year, next year.
So they won't be able to help between now and
December
31st.
No, so they will not see utilization of those until we get the NRC authorization, and that's going to be the final point. And we're working very hard with our subcontractor to make sure that we're giving the NRC what they need to be able to allow us to operate the fleet.
Good. More questions? Dan, thank you. I hope, first of all, my apologies for conflict today with scheduling of your, I don't know who scheduled first. I don't know if we
You scheduled first, sir.
Okay, so, and now we know. So,
yeah.
So, but, congratulations on taking that first shipment of federal waste and getting it in your site. I know it's been open for a while and you've been trying to get it in there, so I'm glad it finally happened.
Yeah.
We really do need to understand how to smooth the process of, you alluded to it, of when there are shipments or, we had this operational year concept, now we have we are looking for you to participate with us when we go over these rules on how to make that work more smoothly from a practical sense, because we don't know what you face as a practical situation, and we anticipate learning some of those things.
Yeah, we really look forward to the opportunity over the next month or so to start working and providing input to that process, because we have learned a lot in this last year, we've learned a lot. The customers have learned a lot. The commission is learning, and I think this next go around it was appropriate to wait this long, and we really do look forward to providing input into that, because there are a lot of practical matters as we discussed this morning. It's this University of Oklahoma is out there all of a sudden. He's got a can of stuff that showed up, and he wants to get rid of it. And there's a lot of things like that I think we can help with. So I think that's going to be a great opportunity to help.
Well, all of us have to live within the structure that's been set up with the compact and the licensing provisions and everything else. But I think all of us, I know I can speak for myself, and I think most of these people, we want to make it as workable as possible, given what we have learned. So if we can think outside, if we could come up with a structure that makes sense within the framework of the legislation, we're interested in hearing about that.
We will certainly give you every effort that we can and counsel that we can on during that process.
Okay, Dick.
I have 2 questions. Number one, you've given us an annual report. Can you give us quarterly reports?
We report monthly to you already, but we can.
To us?
We send those to Lee, yes.
We get monthly reports?
Is that not correct?
I didn't realize that. Okay.
Yeah.
Sorry.
Is that not correct? I thought we had been.
You do. And we get them every month. As a matter of fact, the month of May is under the next tab, because what you're bringing up is something we were going to discuss as the next agenda item, the idea of volume and curies and how we get it reported to us and those sorts of things. And their May report and then their annual report are under tab number 25 in the notebook.
Okay, I missed that. Okay, thank you. And the other thing, we've always been somehow believed that the additional income from non-compact waste in effect backed off the expense to compact generators, in effect, kind of subsidize the operation that way. Is there a way that the federal facility figures in there, or are you treating those two facilities completely separate? I mean, I would think that you must have some economies of scale in operating two facilities rather than one.
Mm-hmm.
You must. I mean,
yes,
certainly you do in management.
Yes, sir.
Is there a way that generators in the compact facility, in effect, benefit through the back door in their rates because of the existence of the federal facility?
Yes, sir. It is. It's absolutely, that's the construct of the entire enterprise. Diversification
where does that
of product
come
and
out?
customer.
Does that come out in the rates that are set by the TCEQ, or?
That's the under the rate setting rules. Yes, that is where it manifests itself. So, and as you're aware, the rate setting rules, the simple version of it is the rate that the rate setting establishes a cap, the highest price that we can charge to a commercial in compact generator, and then conversely for anyone out of compact, they can't be charged any less than that. So, but there's a complicated process through the rate setting application and things of that nature that we could talk about for hours. But the fact of the matter is there are values associated with that importation that are allocated to the in-compact generators, and the same concept goes for the federal facility as well.
One of the reasons I ask is that it strikes me that with the imported waste coming in as fast as it is, as compared to the in-compact waste,
mm-hmm.
the imported waste will build up and will fill its quota
mm-hmm.
in X number of years. I don't know how many, but it won't take all that long because
mm-hmm.
it's coming in pretty fast.
Mm-hmm.
And then you won't have that cross-subsidy from that to cross-subsidize the in-compact generators.
Mm-hmm.
Now, if you take Vermont, for instance, if Vermont doesn't decommission its plant, for instance, for another, say, 10 years,
mm-hmm.
something like that, 10 or 15 or whatever, at that point, I'm wondering whether the rates are going to go through the roof for in-compact generators, or whether the existence of the federal facility will ameliorate that situation.
I think the answer to your last question is yes. That's the construct of this whole enterprise. I mean, the original law allowed the federal facility to be built because of that very reason. So that's an ongoing long-term concern, and as long as we provide value to the federal government, they'll continue to use us. With respect to the out of compact, that will be, we anticipate that we will be able to sustain importation for quite some time. It's not 2, 3, 4, 5, 6 year time frames. It's the entire license period for our first license, we believe. So
let's assume that you can't take into account the decay of the waste that's on site. About how long do you expect you're going to be taking imports? What's your projection on that?
Well, I don't think that's appropriate. I don't want to speculate on it either, because I think that matter is, like I said, our license is pretty clear, I think, and I think the folks that we'll hear more from that as we discussed this morning. So I don't think that's going to be an issue. it would just be speculation on my part. I mean, if you can divide 1.1 million divided by 275 if you'd like, if you make that assumption, which would be a problem. But I don't think that that's the appropriate reflection of what we have before us.
Well, let's see, if you took 275 a year and you've got 1.167 million or whatever, is that apples to apples?
I've done the math.
Actually, I think what you have to do is, before you do that, you have to subtract the amount that we disposed of during the first operational year.
Yes, you do.
Okay.
It's still not very many years, no matter what you do. I mean, it's pretty simple. I mean,
yes.
But as I said this morning, this is it does seem clear that 30% of our license as measured in our license, which is determined by our license, and that's to include decay. So it's an intellectual exercise of some degree in that respect. So.
Dan, thank you.
Okay, thank you.
Look forward to talking to you all more. And again, I apologize for the conflict with schedule.
That's good.
All right.
Can I bring up something while I got it on my mind?
Of course, Judge.
You said something about Oklahoma and which reminded me of the disaster. Sorry, I just got a piece of chocolate. Can we put something in the rules about if a state has an emergency, some disaster happens, that we can look at that we may suspend our rules in case they needed something moved? Still within local government code, TCQ and all that. But
we're opening up the rules for a general discussion, and yes, if you, I'm sure Lee is making a note about that as we speak.
In case a seal source got thrown 2 miles and they had to pick it up and all that stuff.
Yes. And as a matter of fact, if I can go all the way back to the original compact, there was discussion about allowing out-of-state, out-of-compact waste to come in for just that reason, that there might be a disaster somewhere and we might need to open up. At that time, the compact was intended primarily for Texas and its partners. And they said, but we might need to open it up, so they added those provisions into the compact in 1993.
I think the South probably got the license to hold it until it got through the system probably, but it's just some idea I had.
Again, I don't want to talk for WCS or TCQ, but the constraints may be in the licensing area rather than in our area.
Yeah.
Yeah, WCS would be very supportive of this thing, because we do have this storage license and processing license to additional waste and all.
Okay.
I'm good.
All right. That takes us down to item 12, discussion of possible action regarding reporting of volume of curies of waste into and leave.
This is following up to an issue that was brought up by Commissioner Commissioner Sadek and Commissioner Saunders last April as it related, at our April 18th meeting, as it related to the reporting of volume and curies that had been disposed of at the site, and what were some of the needs of the Compact Commission in having that reported. What would they like? What would the commissioners like reported? How often would they like it reported? To what extent we would put that publicly on our website. That was to build on that. This item, more specifically, is to build on that discussion that was started last meeting.
Thank you. Appreciate getting these periodic reports.
What do we need? Do you have ideas about specifics about what you would like to see or we need?
No, well, these I like all these colorful reports.
Maybe a bigger typeface.
Not like that. I think it's very useful for us to have kind of running total to get a sense of what's going on.
We may need to get a bigger printer.
Yeah, either that
Very
or,
tiny.
A
yeah.
54-inch or one of those.
Maybe you should come with magnifying glass.
Is there anything else on this item? Okay.
Yeah, and for our purposes, for the discussion that we were talking about, putting this, the other aspect to this that we discussed in developing this agenda item was the fact that the one thing that the compact absolutely has jurisdiction over is maintaining capacity for the party states. And so the goal of this was not only to address the concerns that Dick and Jane have. I've always wanted to say Dick and Jane and the concerns Dick and Jane had, but also the issue of what would we want to report out so that we have a sense of what the capacity is, how that may also relate to having to potentially get reports from the TCEQ about what's coming in compact, so that we have an overall concept of what capacity is being used at that site overall. And do we want to do something, get those sorts of reports from TCEQ? Would we want to put something on the website that keeps a running total as it relates to the overall capacity used and left at the facility, and then reflects back on us as we are responsible for ensuring capacity for in compact states?
I would add that I think it would be useful if we were to put on our website a report that would be available to everyone that would indicate both in compact, Texas and Vermont waste, and then out of compact waste, and perhaps, I don't know, maybe monthly is too often, but maybe something like quarterly, where we could provide that on our website for the commissioners and anyone else who would desire to see that information as sort of a running total. Do you think something like that would be doable, Lee?
I haven't talked specifically to TCEQ about this issue of getting that data, but I strongly suspect it would be possible.
Dick, do you think that would sort of meet your needs as well?
Yeah.
I mean, I desire the same information you do, so I echo your thoughts.
Some of these things are marked confidential, and I wouldn't want to. I'd want to be sure that it's legitimate information to release. But having said that, I think a running totals was quarterly or whatever are a good thing.
Yeah, it wouldn't have to be by generator. It could just be in compact. Yeah.
I agree. I don't necessarily know that we need the detail of how many microcuries any particular generator shipped.
Yeah.
More of just the total of what's being shipped.
Totals, yeah. And I think they might be, of interest to Andrews County, for instance, to have a real sense of actually what's come in. And,
yeah.
So if I could take a stab at repeating what I heard as something that the commission would like to see, is y'all would still like to see the monthly reports that WCS submits that are as exampled by what you've seen, that those would be something that y'all would like as commissioners to see. They're confidential, but that's helpful information to you. But also helpful would be something we would put on the internet that is a running total, just a total, not by generator and isotope, et cetera, but a running total of what is disposed of at the site, both in compact and out of compact, and putting that on our internet page.
I would think so.
Okay.
Quarterly.
I think quarterly is probably often enough.
Now, as perhaps for the current year, the current fiscal year, as well as the total capacity of the site. You could maybe have both of them.
Okay. Thank you very much.
I would note that the context for this is a provision in the compact that says one of our jobs is to assemble and make available to the party states, to the public information concerning low-level radioactive waste management needs, technologies, and problems. And I assume capacity would come within that.
It certainly could.
Okay. All right. Is there more discussion on item 12? Suggestions, comments, questions, helpful information? Ms. Haddon.
A brief request. I think this is great. I'm glad that you'll be doing that. I would like to request that those totals be monthly if it's not too much difficulty. Sometimes the quarterly could be difficult in how it falls in terms of when compact commission meetings are and so forth. Thank you.
Thank you. All right. Nothing else on 12. Item 13. This is one that as it appears, is probably from its length, is something that I came up with. And the question has to do with, we get regular reports from some, like WCS and TCQ, but there are a whole bunch of entities that we've learned, particularly since the site opened, that have an interest, and it's becoming a higher interest in a lot of what the Compact Commission does, because we've got this new site. And so this was a discussion item really among the commissioners. Should we, and you know, Lee and I developed most of the agendas with some suggestions, but should we have periodic, and not every month or not every meeting, but occasional reports? And I've got a whole list of entities in here, and you'll notice it starts with Andrews County Judge, and that's particularly true because y'all have a big interest in what all is going on, and you're here as county judge, but you're also here as a commissioner to represent those interests. And I'd kind of like to hear from every once in a while from how things going for you up there, you know, and so that's one of the reasons that I have it on here. And we've talked about brokers; they're on here. Compacts, Kathy, you've been very helpful to us, particularly today, to answer all our questions. And we get together under the flag of the Low-Level Waste Forum with states, and we have a lot of these discussions here. But the people here are not necessarily privy to those discussions, and it would be helpful to all of the commissioners who don't regularly attend the Low-Level Waste Forum meetings to hear from time to time from other compacts and about things like the questions that you were answering for us today. So maybe we can make pieces of this puzzle fit together and actually show us a picture of the way it's supposed to look. Companies holding importation agreements, how do those work for those companies? And I could go down the list, but Radiation Advisory Board is having a meeting on the 21st. I've been going to those, but maybe somebody from there should come to us, the Texas Radiation Advisory Board, and talk to us about information that they'd like to have from us. Processors, the Nuclear Regulatory Commission, and they might not. I would love to extend a request to them to come down from time to time to tell us we keep up with what they're doing through the Low-Level Waste Forum and reports, but we have interest in things like downblending and packaging, and I noticed that they have another one coming up on changes in the manifests and how that might affect our record keeping and what we do and all of those sorts of things. It would be interesting for us, and who knows, they might even want to hear from us, although that's more problematic. Peter used to be on NRC. You can tell us about that, and I don't know.
I'm sure if we invite NRC to come and talk to us, they will do that. Exactly how much they'll listen to us is something I'd be less confident about, but I don't doubt that someone would come.
Well, they have an office up in Arlington, in the Dallas area, so it wouldn't, assuming those people are, and I assume that they would be knowledgeable about what's going on in NRC, and I assume that they would be curious about what's going on in Texas, in all honesty, for all sorts of reasons. I mean, particularly now that the federal site is opening. They're probably here.
Well,
we just don't know it.
31 years since I left the place, so my contacts with the staff aren't what they once were, but if you would like me to pursue that, I do know the chair at least, and so I dare say,
well,
we can get somebody here.
Really, one of the things I was doing is just saying this was an idea I had, and I was just going to test the other commissioners to see whether or not you thought it was worthwhile or not, because these meetings can go a little bit. But I think that on occasionally, once or twice a year, we might get some of these groups together. Mark, you're out there. You represent one of the generators. You're here all the time, but you're here on specific problems. And what we don't always hear, and Eddie, this applies to you, is, and Tom and the rest of you out there that represent generators, is we don't often hear about your ideas about things that are not on the agenda that you might want to alert us to and say, have you thought about this? Or how do you take, we see this coming up, how do you take it into account? From our perspective, one of the big questions most of you know that we've had is what happens when we sign these importation agreements. We get importation agreements from people, and we, our first expectation was that they would not apply to us for some capacity of curies that they did not intend to consume. We've learned differently. So what do we do about that? How do we make it work for everybody so that, and I'm with the judge from Texas point of view. We know what the legislatures want to do. They're looking at it from a revenue point of view. They want to maximize the revenue associated with it. We want to make sure the site has revenue coming into it for all sorts of reasons on a continuing basis. So when Vermont starts its shipping, the per unit cost is as low as possible. I'll just put it that way for operational cost. And so I'm just thinking maybe we need to get some of these folks in here every once in a while and start asking them, what do you think? Tell us what you think about these kinds of ideas and the way this works better or worse. And that's the way I put it on here. And if it's okay with you guys, we'll start sending out and trying to set up a schedule for these things to come in. And Judge?
I was sitting there, I don't have anything for Andrews County. Peter, our schedule in Vermont's not as timely as it is. I mean, the agenda's not like it is. NRC might want to do something in Vermont that we can do in Vermont easier. We can do it here.
They certainly are focusing a lot on Vermont these days.
It would heighten the visibility of our meetings somewhat.
Okay, well, we're going to work on that if y'all think it's worthwhile. And that was one of the ideas I had. If you could think of somebody else that should be on this list, but we haven't thought about or I haven't listed, just let me know, and we'll sort of figure out a way to work everybody in on some scheduled basis that makes sense to us. Okay. That's all on 13. 14, report. I don't know what I have to report, quite honestly. We've been talking about the legislature. The audit is ongoing. I'll report this to the commission. I got a call from the auditor today. He said there's a different description in the compact from in our bylaws about the breadth of the audit. I'll put it that way, the rules that apply. And so he's going to have to do a little more work, and he was telling us his answers, all that. I also learned that he is, for the first time, realizing that we had expenditures in the year ending August 31st of 2012 from something other than an appropriation. And so we did, and most of you are unfamiliar with the details of that, unfortunately, so I have to, and Judge, you and I might have to be the ones to go back, because these has to do with the operations we were running for a couple of years when we had an interim executive director and all that. I think we can answer all those questions, but it'll be just a little bit further. And Dick, thank you for your comments to my report draft. I'll take sure, and we're going to see whether that can get out by the end of the month.
It took 6 months.
So
they were brief.
Yeah. The next one, well, and that's the old saw, you know, you had enough time to make them short. So the next one, we will have learned a lot more. We've talked about the rulemaking. Let me see if there's anything else I want to talk about. The Low-Level Waste Forum fall meeting is now scheduled for, it's late October, but registration has opened for that meeting, and I knew that.
Park City, Utah.
Ma'am?
Park City,
Utah. October 21st, 22nd, 23rd, as I recall the dates. And we are a member of the Low-Level Waste Forum. We received our notice of dues, and I sent it on and requested it be paid. Really don't know what else to say. Most of the time we were spent sitting around here in this building listening to people talk about proposed legislation. I didn't say very much. Didn't have to, because we didn't have much directly involved, although there was a lot of activity going on in the background. And I really don't know if there's that much else going on. Next meeting, and I'll just go ahead and talk about this now. I know Lee's going to talk in a minute. But the next meeting is going to be, we're going to concentrate on fiscal matters because we have to adopt a budget, and we'll be looking at that and expenses associated with that, developing that in the meantime. And also our contracts of our 2 contractors are coming up for agreement. We'll revisit those in August for Audrey and Lee. And I don't know what other contracts we have out there, but we should be good to go on the fiscal side of things, I hope. Dick?
May I just, do I have it right that in the final version of the legislation, our budget goes somehow from the security that's put up to the TCEQ to us? Is that the way it works? The money? I mean, no, it changed on its way through, didn't it?
It did change on its way through, but the reason it appears to have changed so much is that one bill was added to another because of the situation in Texas where one bill failed and they were able to do some amendments on the House floor. But the basic structure of your budget did not change, even though there are words in there that might lead you to think so. The basic structure of Senate Bill 347 did not change, and what that does is take money out of Fund 88 and put it into 5151, which is your fund, in an amount equivalent to what the legislature appropriates per annum, which is 578, I think.
589.
And then there's at the end of each fiscal year, there's a leveling process. If you have too much left, it gets swept and put back in 81. If you don't have quite enough, it gets leveled. So you always have the 589 per annum. And that's the basic structure, and that's unchanged. I
did not mention the appropriations bill, but there was an appropriation from the state of Texas to fund the operations of the Compact Commission. And that comes out of a particular fund. The problem is, how is that money going to get into that fund? And the bill that was passed was designed to address how money came out of a fund that has a lot of money in it to go into the fund that funds us and then that fund builds up over the course of a year, and then at the end of the year it goes back the other way, basically. So it's always evened out, and it solves a big problem for us, which was we didn't know how much money we were going to have from year to year. Now we know. And so, we'll have to look at it. It depends on the appropriation, but right now the appropriation is the amount we have budgeted. And so we're good. So, what it did is smooth the mechanism about funding to where the comptroller now knows how to move money around within the state of Texas. Does that answer your question?
Yeah, I guess so. Yeah, I guess, does it originate from the import funds? I mean, where is there some sort of...
The money that you spend comes partly from... The money that you spend comes partly from import fees and partly from fees on in compact generators. And the amount that you have to spend is what the Texas legislature appropriates, which this year is $589, and what next year is $589.
That's right.
The money that fills that account actually initially will come from Fund 88, which is a very large fund. It has...
I believe it includes the money that came from the state of Vermont.
Yeah.
So it's quite large.
Yeah.
So that money first fills up, is the first thing that goes here for y'all to spend. Then the fees that are collected are accumulated, and if there's not enough of those, you get to keep what came to you from Fund 88. If the accumulated fees are too much, then those go back to the general revenue fund. So,
okay, that's more than I need.
It's a very, very elegant solution. Thank you, Betsy, to the problem that we were facing, and Betsy back here gets full credit.
Fund 88 came from TXU and the low the money off of the 2 power plants.
And from Vermont.
No, I meant the
It also came from Vermont.
original money from the old compact commission that never got brought up. It was collected and never spent. So it's sitting there too. And then since we got appointed 4 years ago, they're using that money that was collected by the generators a long time ago, 70s, 80s, to have this fund. Because in Texas you have to balance your budget. The comptroller has to tell this body it has a balanced budget. And that money is used to balance the budget. But that's where the big money came from, the generators. Now, I just wanted to tell them that because that's where the money came from, the big money.
Yeah, in Vermont, I think Vermont wrote the check that they got it from the generators. It's 6 of one, half a dozen the other.
What's the name said that early on?
Yeah.
That happened. I guess it happened in both states.
Any more questions? Okay, Lee.
The only thing I have is to add to what the chairman's already brought up is that, yes, at the next agenda, that's going to be our big budget agenda. So what you'll be seeing coming your way prior to that are draft budgets for y'all to look at. It's going to look remarkably similar to the one you saw last year. And one of the things that you might want to think about that I'm considering adding to this budget is a process audit for our office. The audit that you're having done now that the chairman's talked about is really a financial audit required by the federal compact to do. The process audit that I'd like to have y'all consider is not required by federal law, and the state law doesn't speak to it. It's just now that we've been up and operating a year, I'd like to have an independent auditor come in and look at how our office operates, what data do we not keep that we should, is our filing system is complete, things like that. So that's something another item you may see in the budget this year that wasn't in the budget last year. Also, not only will the budget come up to be approved, and of course, as the chairman mentioned, the executive director contract and the executive assistant contract, but all of our web associated contracts come up for renewal too. So those will also be on the agenda associated with keeping a website, somebody to maintain it, the contract that we keep so that we can go in and change it. There's a bunch of little web contracts I never knew you had to keep a web page that you have to have that you will see, and we will explain to you ad nauseum if you'd like, between now and August 8th when all of these will come up for your consideration and approval. So I just wanted to let you know, stay tuned to your email so that you can see these documents begin to come your way. In the next couple weeks they'll start showing up. And that concludes my report.
Very efficiently done. Next, discussion and possible changes of dates and locations for future meetings. The next meeting is scheduled to be August 8th in Austin. Do we have a room location yet? Not yet. Okay, so it's scheduled to be August 8th here. The one after that has now been tentatively scheduled, or it has been scheduled.
It has been scheduled.
It has been scheduled for Montpelier, Vermont for October the 2nd. And after that, we don't have anything scheduled yet, do we?
No, we absolutely do not have anything scheduled.
But we have another meeting or two to think about that. And probably we'll get back to that in August, I would think. Because by that time, we ought to know more about the impact of the legislation, and we'll know a little bit more about what we're going to do on the rules. And I think that all of those things might coalesce into a better picture of when our meetings need to take place. And John will be relocated to Austin by then. All right. Any other comment from any other commissioners? Questions?
I'd just like to say, as the one who lives in Montpelier and works in Montpelier, anybody has any questions, about lodging or any of that stuff, distances from airports, how we usually try to get here from there and there from here. Just give me a call, and that goes for anybody in the room, not just the commissioner. I'd be happy to try to figure it out.
That was the easiest way.
We're very flattered that you want to come back.
That was the easiest way.
But that was in Burlington last time.
Yeah.
Burlington. You can fly into Burlington, yeah. There are other. I flew out of Manchester, New Hampshire this time, and that's about a 2-hour, 20-minute drive for me. But that's simply because of the scheduling of Southwest and that sort of thing. Southwest doesn't fly into Burlington, which creates problems. The other thing is that JetBlue used to have more service from here to Burlington, and it's very sketchy now getting there on JetBlue. So it is a kind of a pain in the neck going the whole business flying, but we've now had a fair amount of experience.
Peter,
I could get to Manchester, but I couldn't come back.
Peter, do you fly out of Albany?
Yes, which is the closest to my home, but a long way from Burlington. But if anyone does that, come visit us in southwestern Vermont. Those of us who live in southern Vermont are sensitive about the fact that most people in Montpelier don't know we're there. It's sort of like Maine turned upside down, and the people who live in northern Maine have the same attitude.
We have the same town in Texas called El Paso. We don't know it's there, and they don't know we're there. A million people.
Well, that's the thing. Here you can lose a city of 1 million people. In Vermont, we would know about that.
All right. If there's nothing else, we'll be adjourned. I'll just announce it. I won't even have a motion. So we're adjourned. Thank you for everybody for being here, participating, and we'll keep everybody posted after the 28th about what we're going to do on the road.